My lords, kind leave to mention a matter for inclusion in your lordship's list, my lord, upon notice to the other side, my lord. It's an appeal preferred by the appellant under section 37, my lord.
Inclusion, just hand up the slip.
Grateful lordships.
Said appeal under section.
Nina.
Appellate said.
Appeal without the certified copy.
When was the order passed?
There are two orders which have challenged. One is of 7th April, the other one is 29th April.
Applied?
Yes. I'm grateful.
And my lord, kindly to mention, my lord, the electric steel's, my lord, appeal, my lord. The electric steel appeal, my lord. Union's appeal. It was kept, my lord, today at 3:30, my lord. The resolution at 3:30, my lord. I'm seeking, my lord, it will be kept at 3 p.m. today.
Your Lordship, I am for the appellant. If Your Lordship, I am for the appellant. It had fallen from Your Lordship that the learned ASG, Mr. Vikramjit Banerjee, is appearing in that matter. It had fallen from Your Lordship that whoever counsel starts has to, midway, submissions won't be allowed by any other counsel. Mr. Lahiri was making the submissions, would start the submission. Mr. Vikramjit Banerjee has requested if the matter could be fixed on 9th or 10th of June. He'll come down physically and he'll argue the matter. Or if Your Lordship allows Mr. Lahiri to argue the matter and
Passed an interim order.
Your Lordship, there is no interim order, Your Lordship. This is...
There is not an interim order, Lord, by which, Lord, we have withdrawn the amount upon furnishing bank guarantee. Lord, the amount, Lord, is 252 crores, Lord, the renewal which is due in June, but will cost my client substantially. Lord,
9th and 10th June, Your Lordship, or Mr. Lahiri can make the submissions.
So
if Your Lordship...
You compensate that for the...
Your Lordship, if Your Lordship allows us to, Mr. Vikramjit Banerjee to take up the matter on...
Of course, we will allow. Pandey, please understand. Please understand. We'll be happy to hear him. But what they are saying, have you considered that?
Your Lordship, today we are ready to argue the matter. It's not that we are not ready. If Your Lordship, we are ready to argue the matter at 3:30, Your Lordship. We are ready with the arguments, Your Lordship.
It won't finish today, Mr. Sinha. So for half an hour,
tomorrow,
half an hour, it's no point.
Mr. Banerjee will be
We'll
just
see
adding
that
1 or 2 points.
No, it has to be next week. Already fixed.
Next week, Tuesday or Wednesday.
Okay. 15th May is possible.
Lordship. In the morning.
3:30.
Morning, in the morning, Lord.
No.
3, it's not 3:30, Lord. If it could be 2 o'clock.
It's a Wednesday. No, Thursday. But then Friday is not a holiday.
Monday is holiday. Friday is not a holiday.
Let it be 3:30.
Thursday, Lord, at
3:30, 15th.
15th of May. Obliged, Your Lordship.
3 p.m. Lord. Instead of 3:30, could it be 3 p.m. just in case?
Other matters are there, Mr. Sinha. Anyway, if there's a 3:30 rising, 3 o'clock will not really help.
No, we'll make some progress, but that's what you're...
Half-hearted, let it be 3:30 and pray to the Almighty. That's all I can say. For everybody's good health.
With the leave of Justice Raiman and mention at the Palanco plan it was fixed today at 4. But if the lordship fixes another day,
yes, I can't do this sitting on this bench. So can you? Sinara Shaibir Kobe.
Request if it can be soon, my lord. I'm request. I know you're.
Yes, we can't promise anything. Hand over the slip.
The lordship knows it won't take much time. It's just that it matters been dragging on, my lord.
Do you know the load that we are carrying, Mr. Mukherjee?
Well, that's why, my lord.
Yes. Next.
Any mentioning on your side?
Any appellate side mentioning?
On your side, non-commercial matter to be mentioned, item number 1. Pass over.
Number 1.
Number 2.
Huh? Non-commercial.
Yes, non-commercial has been called.
Yes.
Lord, your lordship had asked me, Lord, I had circulated yesterday that non-commercial
You are appearing.
in item 2, my lord, item 2.
Item 1 pass over করবে আর কি করবে? The item 1 non-commercial
Non-commercial.
13th May mark করা আছে তো কি করছোটা কি? কোন সাইড? ও অরিজিনাল সাইড। ও আচ্ছা আচ্ছা। Why is it appearing as to be mentioned?
I wanted to withdraw the.
Oh, very well.
As per the Supreme Court order, they are paying, they have been paying us.
Oh, very well. Learned advocate for the appellant says that the matter has been settled out of court. Stop. He, on instruction, seeks leave to withdraw the appeal. Paragraph, APO such and such is dismissed as withdrawn.
That will record the order of the Supreme Court in the order.
Not necessary. You are submitting. It has been settled. Settled.
Appeal letter?
Appeal from order, old matter. Item number 2.
My lord, I appeal not for the state, note. There's an appeal by the state of West Bengal. My lord, this note, as your lordship note can see from the number, it's a very old appeal. My lord, the records were not being found. My lord, with great difficulty, my lord, I've been, and the previous advocate on record for the state is also no more. So, my lord, with great difficulty, my lord, I've been able to, my lord, get, my lord, the copy of the stay application, which has the plaint annexed. And, my lord, it was decree, my lord, where the state had not filed the written statement. So, my lord, probably that is the only document which will be required. My lord, there's a direction, but there was a direction, my lord.
Memo is not there.
Memo is also there. So, my lord, I'll have the memo, the impugned order, and my lord, so, my lord, I'll make a paper book, my lord, of the stay application. And my lord, we tried to serve the others, my lord, the plaintiffs, my lord, they were not responding. We were asked to make a newspaper publication, my lord, which we've also complied with. So, my lord, lordship keeps it, my lord, 2 or 3 weeks after the vacation, my lord. In the meantime, I'll complete, my lord, the, my lord, I'll. Reconstruction.
We have to call for a report from the department why papers are not there.
You know, there's already a direction, my lord, for reconstruction. No,
There is.
There's already, yes. On, and that's not also long back, but we did not have the record.
13 January 2015.
No. There's already a direction.
We are told by Mr. Sinha, comma, learned advocate representing the appellant, that there is already an order of a coordinate bench directing reconstruction of the cause papers since the original papers could not be traced. Stop. This is a very old appeal of 1997. Stop. Paragraph. Mr. Sinha says that he will prepare informal paper books containing necessary papers so that the appeal may be heard out. Stop. Further, comma. Since the respondents in the appeal were evading service, comma, evading service, comma, pursuant to leave granted by the court, comma, substituted service has been effected. Paragraph as requested, comma, lists the matter 3 weeks after the sum of it. Date দিয়ে দিও bracket, 3 weeks after যত date আসবে।
3 weeks after sum of it?
No,
23rd June.
No, 23rd to 1 first. 1 week.
3 weeks after 23rd.
Your lordship makes it 23rd June, but I think 2 weeks should be enough. I don't. 2 weeks should be enough. Yes. 23rd
2
June.
weeks after
23rd June. এটা immediately
June
করে
23
ফেলো। আমি তারপর আবার থাকছি না, আমি বললাম না
আপনার গাইডেন্স দেবো
আমি বলে দিচ্ছি। I'll just tell you how to do it.
Item number 3.
Led by Mr. Shivshankar Banerjee. I'm praying for Passover.
Passover.
Item number 4.
Passover.
Item number 5.
Same.
Item number 6.
Same.
Item number 7.
This is my appeal, Millet. Did Mukherjee Biswas for the advocate records for this matter, Millet? That since the firm is no more there, Millet, they have granted a change, Millet, in favor of another advocate record. But to find the papers and to bring everything before my lord, I'll seek some time.
1 second. এই কাগজ তো আছে, এই কাগজ নো পেপার। এটা আমি হয়তো নিতে পারবো না। দিলীপ কুমার গুপ্তু। Would you know if Adhip Guptu is a party? Released. Guptu is it. We are not inclined to take up this matter on the personal ground of one of us. Amar namta diye dao. Paragraph, let this matter stand released from our list and be placed before the Honorable the Chief Justice for appropriate direction. Oh, তাহলে অর্ডারও হবে না? অর্ডারটা প্লেস করবে, উনি অ্যাসাইন করবেন। হ্যাঁ, কেন হবে না? Or they are saying no papers are there.
I'm told that the papers have to be traced, but I have also found out from the
ঠিক
department.
আছে, তাহলে just stands released from our list করে দাও।
Well, we kindly mention this, Millet, because then.
Yes, it has to be assigned to somebody.
Yes.
থাক পুরোটাই।
Order has to. Because in all likely will come back to my lords only thereafter. Well, if this mentioning that because of the personal ground of one of the lords, it's been released, if that recording is not gone in.
No, that is there, but we will not then delete that portion where we said that let it be placed before the Honorable the Chief Justice. What our officers are saying, what shall be placed before the Chief Justice because we have no file.
Any which ways the order is subject to correction. Well, when we make an application for.
Once you are ready with the papers, you write to the Chief's office, Secretariat for assignment.
Very well. Very well.
If we can't help you. But you know, stands released from our list, stop. Chalo.
Item number 8.
Pass over.
Item number 9.
Same.
Item number 10.
Same.
Item number 11.
Same.
Second call. Passover matter. Item number 3.
এটা ছিল পাস ওভার চেয়েছিল। ছিল পাস ওভার চেয়েছিল, ডিসমিস করবো না তাহলে। নট টুডে করে দাও।
Item number 4.
এই তুমি জানো তো ইউজুয়াল অর্ডার যেটা আছে।
Item number 4 অর্ডারটা হবে।
Who dismiss?
Item number 5.
Same.
Dismissed. Item number 6.
Same. ঝাড়ু দিয়ে দিয়ে বার করা হচ্ছে।
Item number 8.
Same.
Item number 9.
Same.
Item number 10.
Same.
Item number 11.
Same.
New application, item number 12.
Lord, this is my appeal, my lord.
Pass over.
Item number 13 and 14.
Pass. নেই তো আছে? Mr. Sinha, item number 10, you are no more appearing. Your name appears.
No, no, we had given change. We had given change. We had given change.
কি হলো এটা আছে কেউ?
13 and 14.
13, 14 নেই, চলো
Pass over.
pass over.
Item number 15.
My lord, 15, my lord, is my application, my lord, for discharge of Mr. Deepak Dev, my lord, as the receiver lordship recalls, it was taken up last week.
Yes.
When, my lord, one of the applicants, my lord, on whose application that order was passed, my lord, Mr. Sharda, my lord, he could not be served at that stage. Your lordship asked me to serve. My lord, I ascertained from Mr. Aditya Kanodia, my lord, he represents him, my lord, so I have served upon him, my lord, a copy of the application. My lord. This is the affidavit of service, my lord. My lord, if your lordship is not displeased to yes. My friend appears, my lord.
You appear?
So, my lord, the only prayer, my lord, is for, my lord, discharge of the receiver, my lord, and appointment of any other receiver in his place, my lord, and whatever remuneration, my lord, your lordship, my lord, for his services, my lord, for all these years, my lord.
What was the, what were?
Enters into the merits of the matter, my lord.
Merits of the matter?
Merits.
We were served with this application. I have sought for instructions with respect to whether we can give consent to this application or not. I will kindly let the matter stand over for the day, my lord. Possibly
Very well, of course.
Whether you can give consent. Who has asked for your consent? Have we?
No, my lord has.
Then?
I was just seeking time for.
That is an entirely different thing, sir.
Yes.
We don't wait for your consent.
I apologize, my lord. I was not seeking to stand in the way of the court's adjudication of the matter, my lord.
My lord, he has stated, my lord, that for his health reasons, he is unable to continue. So, my lord, he's suffering from cancer. My lord, I have next documents in the application.
No, I know.
Yes. So, my lord, there is, he's just not in a position to carry.
Anyway, he wants a day's time.
Yes,
come
my lord,
back
I'll
tomorrow.
not stand.
Just suggest some other names.
I will come
Both
back.
of you
Lord,
decide.
I'll come back to your lordship.
Not today.
Not today. No, not today. Item number 16.
Lordship, for item number 16, 17, 18 and 19, this is regarding
for
that
the
Marshall House sub lessee matter, Lordship. Mr. Obrujit Mitra is leading me. Lordship, may I seek your kind indulgence to kindly, subject to your convenience, fix it for 3 p.m. because Mr. Mitra
Then
is not.
can it be taken up tomorrow, your lordship, in that case? Your lordship?
Receiver is supposed to go
Tomorrow.
Sheriff is supposed to go today for taking possession. That is why
If you are seeking accommodation,
Lordship.
then sheriff shouldn't go today. Very simple.
It's not going, Lordship.
No,
The
but
order,
so-
Lordship, the order of the learned lower court below is very clear that the sheriff may go after 7th of May.
Today is the 7th.
Today is the 7th. He is not going, Lordship, today. There's no.
I don't know, Milord. We shouldn't go. Well, I have no Milord.
After 7th is not today,
Like,
Mr. Ghosh.
After 7th of May.
Come back tomorrow.
Lordship, obliged.
Tomorrow, he says.
Tomorrow, your lordship is.
You are not leading him?
No, I am in a
Different matter. 16, 17. He is in 18 and again I am on 19.
Come back tomorrow. We'll dispose of 4 appeals.
Lordship,
Not today.
obliged.
Very short point, your lordship, that whether
read the
decree is
judgment.
bound by-
Justice Parthasarathy said.
Yes, your lordship.
Yes, yes.
3
lakhs cost.
orders in respect of cost.
In one matter, 3 lakh each. There were six petitioners. That is you.
And me
That
too,
we
your
may
lordship.
consider reducing a bit. But
I have something to say on merits. Milord. I can't.
of
say-
course, you have been briefed. You have to say something on merits. Come back tomorrow.
May I come back tomorrow? New application, second con. Item number 12.
Lord, this is my appeal.
Yes.
I will take it up next week. I have Mr. Mitra is leading me.
Mr. Obrujit
Yes.
Mitra. Who's on your other side?
Other side, my lord, again, Mr. Mitro, Shurojit Nath Mitro.
Very well. The respondent is not, what kind of a matter is this?
My lord, this is an appeal, my lord. Execution was filed, my lord, in High Court from an order, my lord, passed in 10F appeal. Our contention is that, my lord, execution is not maintainable here and it should be before the NCLT.
The respondent is not represented. Stop. Ms. Banerjee, appearing for the appellant.
I appear for the response.
Yes. Yes. So you're ready in the matter? We have heard them. You have to now argue. No, so what can be done? So either do it or we'll adjourn it. Any other day. Which day, Ms. Banerjee?
14th.
14th? 14th. Yeah, order for a
Item number 13 and 14.
13, my lord, I am for the respondent. And
13.
13 and 14, I am for the appellate. My cross objection is my end.
Oh.
That matter.
Who's on your other side?
Mr. Meghnad Datta, led by Mr. Sabyasachi Chaudhary.
Prabhushai Chaudhary. What should we do, Mr. Mandal? They are not here. Huh?
Any date, my lord.
We can say not today only. Not today. You please inform Mr. Dotto.
I will inform.
Actually, শোনো ফার্স্ট কলেও তো ছিল না প্লিজ করে দাও যেটা why should we do any exception first their appeal is dismissed we'll hear it appeal dismissed করলে ক্রস শুনতে পারবো না কেন পারবো we'll hear it
Again, file an application for restoration.
ঠিক আছে not today tell them that we had almost dismissed their matter.
Appeal from order item number 20.
Just setting Ms. Banerjee, my lord, item number 12, which is just passed.
Yes.
Instead of the 14th, could it be on the 15th?
15th, that's a Thursday, that's your lucky day. Mr. Mitro's lucky day. All right, 15th.
I have no objection.
15th. 12 নম্বরটা
Appeal from order item number 20.
Lord, this matter, my lord, is also appeal states.
Hey Baba, Rajpath contractors.
This is a different one.
Huh?
This is a different one, not that one.
Are you sure?
100%. 100%. That no connection with that one. Rajpath? না তোমার খুঁজে বার করতে হবে রিলিজ করানোর জন্য। No, why would I want to?
No, this is not a matter we want to get released.
Lordship,
at
I am
once.
suffering and I like to proceed.
No, I am, my lord, this is,
State's appeal, they will have to
Yes.
do it. Yeah.
my lord, I am ready, but the learned AG, my lord, is leading me in the matter, Mr. Dotto.
Mr. Dotto will appear.
Yes. If you're
When
not,
will he
He
appear?
appeared in the trial court.
he had appeared.
When? Tell us.
Today only, today he has indicated, my lord, first half he'll be free. Second half, my lord, if it can be passed over, my lord, pass over hole to ekhoni hoye jabe. My lord, next week then.
Yes, Ms. Banerjee, we have no problem. You can see they are aggrieved. So kindly request the learned advocate general to come and just finish it off.
I am suffering an unconditional stay of an award.
How much award?
4.5 crores principal with interest going to 8 crores.
No, 3.
Anyway,
And from that, we have
Unconditional stay, my
we
lord,
have
because
preferred
fraud has been detected.
Yes, we'll go that.
Fraudulent award.
Lordship, an SLP has been preferred. Supreme
Tell us,
Court have issued
Mr.
notice.
Sinha, we'll pass it over. You want to
This is
Yeah,
call Mr.
Yes, we will do that.
Yes.
We will do that.
This is the Supreme Court's order from that order.
Through the trial court order also.
Yes. Trial court's order while
আচ্ছা পাসওভার করেছে তো
Passover? এই Passover মানে তো প্রচুর মামলা দেখছি।
দেখেছি
হ্যাঁ, Passover করে পুরো তুমি এক কাজ করো, পুরোটাই run through the list. হ্যাঁ, run through the list.
No.
this week.
Item number 21.
My lord, item number 21, my lord, I am led by Mr. Dheeraj Trivedi, my lord. I am prepared not this week, my lord. He's on his legs before another court, my lord.
He's appearing for whom?
For appellant, my lord.
Rejection of plain statement.
Accommodation is sought for on behalf of the appellant. Stop as requested, comma, let this matter stand adjourned for the week.
Tomorrow is the last working day.
My lord, that's
Yes.
why I am praying not this week, my lord.
Sorry.
I'm great.
No, you want us to fix a time? Definitely. Monday, 4:30 p.m.
No. Monday I won't come. Rochi won't come. Guru Purnima.
Buddha Purnima. What? Buddha Purnima.
Mom is holiday. It's a holiday.
I'm great.
13 তারিখ আসবে 13 Item number 22.
22, Lordship will remember Mr. Dhrubogor, senior advocate, was arguing the matter.
Yes.
He shall continue, Lordship. It be taken up in the
He going.
1940. Yes.
Also.
1940.
So what are you asking for?
Lordship, let it be passed over in the second
Passed over?
court. He shall. He's on his way, Lordship.
From
his residence. From his residence. Lordship is aware.
তাহলে তুমি স্টার্ট করবে
না এসে যাবে first.
Item number 23 to 26.
Lordship, in this serial number, my lord, item number 23, I am for the appellant, my lord. My lord, the senior Mr. Mitro was making submission, my lord.
Pass it over.
Very much. 25 is my appeal, Lordship. There is, in the last occasion, Lordship was pleased to record that the issue involved is similar to that of the Jeshop matter. Now, Lordship, there is Lordship, a difference, as in there was, I shall indicate.
Don't worry.
Lordship, in
Yes,
matter
there's a
first.
difference. We'll come back. We'll run through the list, Mr. Mitro. We'll just run through the list and come back.
Will your lordship run through the list and come back?
Yes.
Or go to the other list? No.
No. We'll come back. You don't want us to come back.
Well, to be very frank to you, Lordship, I did not see that non-commercial matters will be taken up today.
No
Because
problem.
In JSOP matter, I have got some substantial argument to make.
Yes.
I shall.
You have just summarized the points.
Yes.
Now you have to amplify.
That's right, my lord. And there are the decisions are to be cited and all that. I have sent for the books and all.
No. You tell us you don't want it today. We'll take it up tomorrow. No problem.
That will be very kind of your lordship. Okay.
We'll take it up tomorrow. No problem.
আমার কোনো inconvenient নেই আজকেও convenient হবে only problem is this my lord I will have to get my books and papers that's all
Tomorrow then.
then tomorrow my lord
Yes.
can it done I'm very grateful to your lordship I shall
Sure.
be very grateful.
Since all the matters are being heard together, serial number 24 is particularly my appeal, Lordship, with respect by the security guards engaged by the liquidators of the company liquidation, Lordship. Now, the only difference, Lordship, is that there is no application filed by any creditor, Lordship. And it was a suo motu order that was passed, Lordship. And the other difficulty, Lordship, the NCLT is proceeding, and Lordship, unless an order of stay, Lordship, is granted, Lordship, the NCLT shall proceed. Lordship,
Hearing it tomorrow? No, we'll not record something. Tomorrow we'll hear it out. চলো এগুলো করে দাও কালকে করে দাও
I'm very grateful.
Item number 27.
Item number 27, my lord. I appear for the appellant, my lord. This is arising out of, my lord.
Respondent?
My lord, arises, my lord, out of an order setting aside an ex-parte decree. My lord, if it may be granted liberty to start, my lord, my leader is on his way, my lord. If I may start.
Pass over? No.
Very
If
well.
you start, you will end.
Very well, my lord. Then I shall come back.
Item number 28. Pass over.
For the respondents.
Pass over.
Item number 29. Pass over.
Pass over.
Item number 30. Pass over.
item number 29 is for the petition.
29. You are for the appellant.
No, I'm for the appellant, my application.
I'm appearing for the respondent.
29.
This matter could be kept on a fixed date post litigation.
What application is this?
My lord, it's an application, my lord. I had taken out an application under Order 12, Rule 6, my lord. Rejection of that application on the ground, my lord, that there's no admission. Whereas, my lord, I had shown the admission, my lord, I had prayed for.
You are the respondent in the
No, my
appeal.
lord, I'm the plaintiff in the suit and the appellant in the appeal, my lord. So it was my application under Order 12, Rule 6, my lord, which was rejected.
Yes.
Lord, it's an appeal from that rejection, my lord.
She wants it after immediately after.
The appellant, my lord.
What is the grave urgency?
29.
She's 29.
Yes, my lord. The order is of my lord, the order is of 2023, my lord, passed by Justice Rao in a non-commercial.
Come back next week. Why are you after vacation?
We'll come back next week.
Not this week.
Not this week. We'll come. I'm great.
Item number 30.
30, my lord, I'm for the appellant, my lord.
Yes.
Yes, my lord. On the last occasion, my lord, I directed the official liquidator to be present personally, my lord.
Yes.
The register original side was directed to serve a notice.
Short passover.
Mr. Chaudhary is appearing.
No.
You're appearing for whom?
Official liquidator.
Official liquidator.
Passover.
Item number 31. Item number 32.
My lord, I appear for the appellant in item number 31. My lord, I'm led by Mr. S.N. Mukherjee. Kindly adjourn the matter to 14th, my lord. He's on legs.
14th.
Grateful, my lord.
On the prayer made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on May 14th.
Grateful, my lord.
14th. 32. Item number 32.
Oh, 33.
Item number 33.
This is an appeal from a decree. I appear for the appellant, manner. I'm led by Mr. Mitra.
It's a perfect example of, my lord,
We have filed process.
the operation is successful, patient is dead.
14.
I have succeeded everything and I really do not know why the last matter. I'll tell your lordships, my lord.
Then pass it over, Mr. Mitra. Pass it over. In the second call, we'll take it up.
Passover.
কবে রাখবি?
Anytime.
Next week.
Next week, my lord, yes.
That is what your junior was prompting. Not this week.
He is always ready.
That we know. We have worked together also. We have, not this week.
Item number 34.
Lord, I appear for the appellant. I'll start. Huh?
Yes.
Yes, my lord. I appear for the appellant. I'm led by Mr. Chaudhary. I'll start, my lord. He'll.
No, you will start and you will end then. No relay.
Well, I'll start then.
Passover, Passover.
Item number 35.
Actually, there are three appeals appearing in the list today, all from the same order.
35, 46, 47.
35, 46, 47 for different reasons. I was the plaintiff in the court below. I succeeded in the suit. I'd asked for a money decree against two respondents, two defendants. I've got the money decree jointly and or separately. I've got the money decree only against the defendant number one. I say that the bank, that is Citibank of India, should also have been directed to pay the decree. Only Citibank has been directed to pay a sum of rupees 1 lakh.
That's correct.
As cost. Now, Citibank has also preferred an appeal, and I have preferred across
So
the
all three parties to the suit have preferred appeal.
Yes, my lord.
because they say that the order is entirely bad. I say that the order is very good. I'm aggrieved by the fact that the Citibank, my lord, has not been asked to pay the decree jointly together with the defendant.
For whom?
My lord, I am the appellant in item number 35. I was the defendant number 2 in the suit, my lord. But I am led by a senior, my lord. I am praying for not this week.
Why don't you make things easier by saying I'm for Citibank?
No, my lord.
No,
I am for the Shonali Mojumdar, the private
Shonali
Mojumdar.
And how many defendants were there?
2.
Facts are very simple.
D1 was the bank.
D2 was the bank.
D1 was the bank.
D1 was the bank.
The D1 was the Citibank. D2 is my client, Shonali Mojumdar, who is the appellant in item number 35.
The decree is basically against D2.
D2.
And D1 has been let away by directing them to pay a sum of rupees 1 lakh.
D1 is represented by whom?
I just tell you, D1 is represented by
Srivastav and Company. Srivastav and Company.
They are not here, Mr. Bose. So either we pass it over or we
My lord,
say not
I humbly pray not this week, my lord, because tomorrow is there. My lord, if it pleases to keep this matter next week, anytime, my lord, all the 3 matters can be taken up.
It's very simple. I tell you, Lordship, I'm the eldest in the family. I applied for letters of administration.
What is your name?
Jyotirmoy Pal Chaudhary. My lord, I applied for a succession.
Does this have anything to do with Nayantara Pal Chaudhary?
No.
This matter?
No.
Or her family?
I have not come across,
No.
at least. Now, there was some money which was lying in an account for which I'd made an application in the Alipur court saying that I've applied for a succession certificate. Kindly do not hand over the money to anybody because the the holder of the account, my lord, has passed away. Bank says, yes, send all your accounts. So all your details. I send all the details.
Owner was your father or mother? Owner.
No,
My
my lord.
brother's wife.
Yes, my lord.
Sister-in-law. But
The elder sister of my client.
now what has happened is, after all this, after acknowledging the fact that, yes, we know your succession certificate is coming, when I go with the succession certificate, the money has been given away to the nominee holder. Now, your lordship knows the nominee holder is merely, my lord, a trustee.
So he is the nominee holder.
Yes, my lord.
That is why the decree is basically against her.
And she has admitted the fact that it is not her money, etc. But be that as it may, the point is very small. But the Citibank, it will be evident if your lordship peruses the record. Citibank knew everything. Citibank did not take due care. The learned judge holds there was connivance and some sort of understanding between the Citibank and the defendant number 2. Yet, my lord, the decree was not passed against Citibank. That is the only small point on the basis of
Why 3 separate appeals are there?
mine is a cross objection, cross appeal.
And 2 appeals.
My lord will then keep it on the 14th, 13th or 14th.
1 lakh.
Nominee could not have taken the money in any event.
When? Monday, Tuesday. Monday is a holiday.
Holiday, my lord.
Then we are opening on the 13th. Keep it on the 13th or 14th.
13th?
All 3.
It is non-commercial, though. কোন 3টে? পরপর দিয়ে দিও।
46, 47.
35, 46, 47.
They'll appear one after the other.
One after the other together on the 13th.
Third learned counsel for the parties, appearing parties. Stop. The banks, Citibank is not represented today. Paragraph. এই অর্ডারটা তুমি করো এতে 35 এ। Paragraph. Let this matter stand adjourned and be listed again on May 13, 2025. Stop. On that date, APD 2 of 2025 as also OCO 1 of 2025 will be listed immediately after this matter.
Just to be on the safe side, maybe on the 14th.
14th, 13th জায়গায় 14th করো. You are for Shonali.
Shonali lost. I think it's a lost cause also. Even here.
Nominee, Mr. Mitra.
Citibank has come.
My lord is reading all the briefs. This is another problem.
Of 2025 will be listed immediately after this matter.
14th. It's a lost cause for us.
Come back on 14th. Why are you aggrieved? Decree is not against you.
They've been asked to pay 1 lakh costs.
1 lakh cost, that is why you're aggrieved.
Yes. Directly by appeal.
You'll spend more on
For the audit.
But
The
the
audit.
whether it's such an appeal is maintainable or not for costs.
very well. Just if you have heard the matter. For it.
Your lordship was told the facts.
Yes, yes, absolutely.
But she was ever this nominee and no answer to it.
Yeah.
Yes. Even I know that.
My lord will kindly answer.
Chalo.
Item
36, Your Lordship, I am for the appellant. I apologize for appearing virtually. Your Lordship, the parties are trying to resolve. There are attempts to resolve the dispute. If it can be taken up after the summer vacation.
Yes, sure. Learned advocate for the appellant says that the parties are trying to settle the disputes outside court. Paragraph as requested, comma, let this matter stand adjourned and be listed again on June 11.
Deeply.
Number 37.
37, I appear for the appellant, man.
Order to wait only for the way to put it. Or this is for the order.
Yes.
37, my lord, I appear for the appellant, led by Mr. Dhruvo Ghosh. He's engaged in court number 9, my lord. Kindly answer Passover.
Passover, no problem.
Item number 38.
Passover.
Passover.
Item number 39.
Mr. Jishnu Shah is appearing for the appellant. He has some personal difficulty. I pray for non-mistake, Your Lordship.
On the prayer made on behalf of the appellant, comma, let this matter stand adjourned for the week.
Item number 40.
My lord, this is my appeal.
Your Lordship, I am
My lord,
for the respondent.
Mr. Shah, Jishnu Shah is appearing and
Your Lordship,
and he-
I apologize. My Lord, there's talks of settlement going on between the parties. We have already offered, my Lord, the appellant. I'm only seeking some time if the settlement could take place between the parties in the meantime, my Lord. We have already offered.
Tell us when you want this to be listed.
After vacation, Your Lordship.
After vacation, she's saying. Huh? You're for the respondent.
I'm for the respondent number 1. Your Lordship, kindly.
Learned advocate for the respondent number 1 says that talks of settlement are in progress between the parties. Stop. Learned advocate for the appellant, you are aware of it? Settlement talks?
My lord.
Agrees. Paragraph as jointly requested, comma. Let this matter stand adjourned and be listed again on June 11.
For consideration, my Lord, of the...
It will be listed on June 11.
Yes, Your Lordship.
Come back with terms of settlement if you can.
Yes, Your Lordship.
Item number 41.
My appeal. My appeal. An order passed in by the learned executing court has been challenged.
Your appeal?
No, my learned friend.
My appeal.
Yes.
An order was passed directing me to take steps to discharge personal guarantee furnished by my learned senior friend's client from the bank. And in default, the direction was coercive steps may follow. That is the order I'm challenging in this appeal. There was a compromise decree which was sought to be enforced by way of the present execution proceedings. And in the compromise decree, there was a term, there was reciprocal obligations. There was a term, 3-4 points, I have points out on law. If your lordship is pleased enough to hear it, I can proceed, or otherwise. The bank was also put on notice.
Second call. We'll just run, yes, second call.
But is it your lordship pleasure to take it up next week?
Next week. If it's your pleasure, we will, sure.
No.
So everyone's pleasure.
Everyone's pleasure?
Also.
Very well, not this week.
Item number 42.
42, my lord, I am for the appellant, my lord. But this is my appeal, my lord, from an order dated 22nd of May 2024.
Respondent is not there. Pass over.
Item number 43.
43 is my appeal, my lord, arising out of a compromise decree passed in an eviction suit, my lord, which was put into execution, wherein, my lord, for the first time they take a point that, my lord, although they themselves had filed an earlier execution and obtained order from the same decree, they say now that this decree cannot be executed. They had appeared. Notes have also been filed by both the parties, ready for hearing, my lord. Any day lordship takes it up. It's an eviction decree, my lord.
Any detail us tomorrow?
I am there tomorrow.
Not today. Please inform. Ask your junior to inform.
I'll give a notice to them, my lord, that it was taken up today and it will be taken up.
The respondent is not represented. Stop. Paragraph. Let this matter stand adjourned for the day. Stop. Let learned advocate on record for the appellant serve a notice on learned advocate on record for the respondent, intimating that this matter will be listed once again, listed tomorrow once again. Stop. If at that time, if tomorrow, the respondent is not represented, the matter may be proceeded with ex-parte.
Grateful.
Item number 44 and 45.
My lord, I appear for the appellant in this matter, my lord. Today morning, they have sent us a letter seeking to replace certain pages of the paperwork which they say are illegible, my lord. We'll do that in course of today. If your lordship kindly takes it up next week, any days, your lordship.
Not this week. As jointly suggested by learned advocates for the parties, let this matter stand adjourned for the week.
8 appear on Tuesday, my lord, 13th. 8 appear on Tuesday, my lord.
Tuesday.
Tuesday.
We can be listed on May 13th.
Grateful, your lordship.
Partial matter, item number 20.
He's coming. Lord, may I?
He's on his way, Lord. He'll be here in 10 minutes.
Lord.
And HM Lord will be here.
Oh, he's coming?
No, the only difficulty, of course, is that both of us not have another matter fixed at 11:30 in the next court, Mr. Shah.
So you want accommodation? We have no problem. Date. Today is a date.
Final hearing ki kore hobe? Section 34.
Oh, this is Mr. Shah is appearing. Na? কাজে করছি তো 4.5 কোটি এটা এখন 8 কোটি হয়ে গেছে
না না কিছু আমি আসছি ভোটে বুঝে আমি আসছি
We'll keep it next week then.
Next week, here, Mr. Shah is
is in difficulty.
Yes, your lordship.
Then after vacation, what can be done?
The week after.
Immediately after, I think lordship
Yes.
can keep it on the
22nd, your lordship, 21st, 22nd.
22nd is the penultimate day.
No, 22nd of June.
No. 22nd, they are suggesting 22nd of May.
No, I'm saying.
Mr. Shah, then come back immediately on the reopening day. Reopening day normally is very light because nobody comes.
One day I am comfortable, but I am very comfortable and very known fact that they won't do it. No, I'm saying one day after you.
10 June.
Yes.
10 June. Do it on the 10 June. On the request made by learned advocate for the appellant, let this matter stand adjourned and be listed again on June 10, 2025, retaining its position.
Retaining his position,
Paragraph learned advocate for the respondents award holders makes a grievance that because of pendency of this appeal and the unconditional stay order operating therein, the award holder is unable to execute the award. Stop. Paragraph. Mr. Sinha, learned advocate representing the appellant, assures the court that on June 10, the matter will be done.
But you may also add that I submitted that unconditional stay was granted for reasons stated in
Yes.
the order and upon hearing.
He also says, he also says that an order of unconditional stay of operation of the award was passed by the court for very good reason as recorded in the relevant order
And upon hearing that.
and on contest.
Very good. Lord, just digressing a bit, Lord, when Justice Ashish Chakraborty used to sit in the other court, Lord, he would always want that two of us should be in court and Lord, we should have some exchange in some matter, Lord, and he would love it and he would just sit down, watch, not react.
Half an hour he pleads to fight and he used to not even speak a word. Thereafter, after half an hour, yes, now it is 11:30 now.
Very well.
Item number 22.
The 22, my lord, is again, I am the respondent here, my lord. State was submitting.
They are.
Miss Nilanjana is there.
Yes,
She was supposed to start.
No, Ms. Banerjee, Mr. Ghosh was submitting, we remember.
Yes.
Where is he?
He's stuck in court 9. He's supposed to come. He said that he'll come, he said so. But
No, we were told half an hour ago that he's on his way.
Yes, he was on.
We asked on his way from where? From Delhi, Bombay. We were told he's on his way from his home. Can't take so long.
And but this is that matter.
Come back tomorrow. What to do?
Yes.
My lord, the only thing, my lord,
Tomorrow.
There's nobody to argue. What to do? Yeah.
I have some difficulty. If
Monday. Monday, not Tuesday.
Monday.
let it again be passed on. Let's
No.
see, my lord, if it's possible to give one more chance, my lord. My lord, because we have been
Passover.
Wait.
Item number 27.
Aryan projects.
Mr. Ghosh.
You're for the appellate, Mr. Mitra?
I am for the appellate.
You want to do it?
I can.
Key.
Yes, it's right.
এটা লিস্ট অফ ডেটস দেওয়া হয়েছিল সেটা কি আছে? না। হ্যাঁ, এই কোর্টে না, এই কোর্টে না। না না এখানে আছে
Thank you.
আছে
মেনশন করে বল।
This is a case, my lord, where I would have liked to place the facts before going into the judgment. Now, short question, according to me, my lord, the short question involved is, my lord, whether an ex-parte decree should be set aside or can be set aside at the instance of a defendant who knows about the suit, does not participate in the proceeding. My lord, the learned judge has gone into, my lord, my faults, my lord. I will try to demonstrate, my lord, that there was no fault on my part. I will try to demonstrate. Now, kindly once before going into the facts, my lord, I shall place the list of dates, but kindly before that, kindly look into the Civil Procedure Code, my lord, the provisions of Order 9, Rule 13. Once your lordships have, my lord, seen that number of occasions, but may I? Order 9, Rule 13. Setting aside decree ex parte against defendants. In any case in which a decree is passed ex parte against a defendant, he may apply to the court by which the decree was passed for an order to set aside, and if he satisfied the court that the summons was not duly served, or that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, the court shall make an order setting aside the decree as against him upon such terms as to cost payment into court or otherwise as it thinks fit, and shall appoint a day for proceeding with the suit. Now, kindly omit, my lord, or kindly, my lord, come to the second proviso. Provided further that no court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in the service of summons, if it is satisfied that the defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim. My lord, I come under this. I'll try to demonstrate, admittedly, before the decree was passed,
March 2019. That we have noticed. Whether that only question is whether that notice on their part absolved you of the duty to serve writ of summons.
Yes.
That is the only thing.
I shall come to the facts now. Now, my lord, for that, my lord, may I rely on, my lord, a list of dates, my lord, which was.
Yes.
May I? আচ্ছা আচ্ছা আগেরটা রয়ে গেছে হ্যাঁ হ্যাঁ তফাৎ আছে My lord, may I rely on this? Maybe some changes were made. I'm not very certain.
List of dates. ওটা ফেরত গুলিয়ে যাবে না, ওটা ফেরত দিন।
হ্যাঁ ঠিক আছে আমার মনে পড়ছে না কিছু Kindly come to the list of dates. ওদেরকে দিয়েছিস? হ্যাঁ দিয়ে দিয়েছি 13th December 2006, later issued by the plaintiff appellant, demanded the principal sum of rupees such and such along with interest at such and such. The said notice was returned with the endorsement refused. Then 14th December 2016 by email, the letter dated 13th December 2016 was also sent to the respondent on their official email addresses. Well, it's at page 191 of the paper book. The said email was successfully served. Then 1st March 2017, demand notices were sent to the respondent which were returned with the endorsement refused. It is at page 193, my lord. Lordships can take note of it. Then, my lord, 8th of September 2017, the suit was filed. 20th September 2017, the plaintiff filed an application for judgment upon admission being GA number such and such. 5th January 2018, writ of summons were lodged with the sheriff's office. 6th of February 2018, writ of summons returned with the endorsement refused. Now, kindly once come to page 215, volume 2 of the paper book. Kindly come to, my lord, page 215. Service report. First, my lord, kindly come to the service through District and Sessions Court, Raipur. The endorsement is could not be served upon the defendant as the company has left the premises about 3 years ago. No intimation. Then kindly come to the next one. I was, my lord, giving them, my lord, notices. I was giving them notices, the first notice or the, my lord, notice in the postal notice that came back with the endorsement refused. Not, my lord, the company has left the premises.
Refused by whom is also the question.
Very well. Email. Email was served. The email, my lord, the letter was served. They have received it. They do not say that, no, my address has changed. Then kindly come to the second part of it, my lord. Postal service through speed post with AD. Kindly see, my lord, the third box. Material received through GPO Kolkata with remarks if any undelivered packet marked refused. This is, my lord, the first. Then, my lord, kindly come back to the list of dates once again. 12th February 2018. The judgment upon admission application was taken up for hearing wherein it is recorded that the defendant has refused to accept the service of this application as also the writ of summons. The writ has been returned with the endorsement refused. The said application was dismissed as the admission made in the balance sheet of the defendant was under long-term borrowing. This is at page 211. Then, my lord, kindly come to the next page, 10th July 2018. Amendment application filed by the plaintiff being GA number such and such, seeking amendment. As GA number 1908 of 2018 could not be served, the appellant prayed for substituted service.
What kind of amendment you were asking for?
One deletion of line that a
Yes,
previously
yes.
instituted suit under
One, my lord, deletion of a line. That, my lord, there was a previously instituted suit by, it's about that. Then kindly come to GA number 1908 of 2018 could not be served. The appellant prayed for substituted service. 14th August 2018. By an order, prayer for substituted service of the amendment application was allowed. Then 24th August 2018. Pursuant to the order dated 14th August 2018, advertisements published in 2 newspapers of the amendment application. But these are, my lord, at page, my lord, 218. Published there, local newspapers, not here. Then kindly come to 13th September, by an order, amendment application was allowed. Then 25th September 2018, the plaintiff through its advocate lodged a fresh writ of summons with the amended plaint. 27th November 2018, writ of summons returned and received by the office of the sheriff with the endorsement, delivery packet marked insufficient address. 13th December, by an order, substituted service of the amended plaint was allowed. Then kindly come to 23rd December, pursuant to an order dated 13th December 2018, substituted service by paper publication was done. 4th February 2019, by an order and in terms of the substituted service done as per the order dated 13th December, the suit was directed to appear as an undefended suit 2 weeks hence. Oh, this was, my lord, the fresh publication was done because of, my lord, the order at page 232. Substituted, so if your lordships are pleased to come to, my lord, page 232 once. Kindly come to my lord page 233. Second paragraph at page 233, the plaintiff is directed to issue advertisement containing the prayer in the amended plaint, being CS number such and such in Central Chronicle, which is an English newspaper having circulation in Chhattisgarh within a period of 4 weeks from date. Then kindly come to the penultimate paragraph, my lord. This caused, my lord, possibly some difficulties. The department is directed to issue fresh writ of summons in relation to the instant suit. My lord, that is not done normally. If, my lord, a person is substituted, then only, my lord, a fresh writ of summons is issued. Be that as it may, kindly come back to the list of dates once again. Kindly come to 46. Kindly come to 23rd December 2018. Pursuant to the order dated 13th December 2018, substituted service by paper publication was done. Now kindly come to page 244 once. Well, the last paragraph, slightly illegible. And you are hereby required to take notice that in default of your causing an appearance to be so entered, the suit will be liable to be heard and determined in your absence. By an order dated 13th December 2018, passed by the Honorable Justice so-and-so, granted liberty to the plaintiff to cause substituted service upon the defendant in Central Chronicle having wide circulation in Chhattisgarh, and made the suit returnable on 4th February 2019. Well, this publication was on 23rd December 2018. In terms of the publication, they were to enter appearance by 7th of January 2019. And my lord, the written statement within 35 days, that was to be filed by 28th of January. That was not done. Now kindly come back to the, my lord, list of dates once again. 4th February 2019, by an order and in terms of the substituted service done as per the order dated 13th December 2018, the suit was directed to appear as an undefended suit 2 weeks hence. Now kindly come to page 246. The order said it would be there on 4th of February. Then kindly come to page 246, 4th of February 2019. Counsel on behalf of the plaintiff has filed the affidavit of service of the substituted service done as per the order dated 13th December 2018. He also produces a communication of the deputy registrar dated 16 January 2019 that records that the defendant has not entered appearance either in person or through its advocate till that date. Accordingly, let this matter appear as an undefended suit 2 weeks hence. So, my lord, 11th, 18th of February. Now, kindly come to the list of dates. Kindly come to, my lord, 6th of February 2019, once, my lord. 6th February 2019. Post amendment of the plaint, the writ of summons of the amended plaint served by the registered post returned with the endorsement refused. Now, this is, my lord, at page 124, volume 1. Now, kindly see, again, my lord, the same thing. so far as the court service is concerned, could not be served upon the defendant company due to non-existence as stated address. And my lord, so far as the registered post is concerned, refused. Now, this was required because, my lord, of the direction given by Justice Bhattacharya that fresh writ of summons has to be issued. Now, since your lordships are at, my lord, volume 1, kindly look into one document. Kindly look into one document, page 121. My lord, kindly come to page 121. ROC records, my lord, service request 11th March 2019. Kindly turn the page. Page 122. Address of the registered office of the company such and such. Kindly come to number 4. Notice is hereby given that the address of the registered office of the company is situated with effect from 11th March 2019. So when the original writ of summons had gone and, my lord, the endorsement was that they are shifted, was not correct. The first one.
What was that date?
I'll tell you, lordship. I'll tell you, lordship. 6th of February 2018. Page 215, volume 2. Lordship.
Yes.
Now kindly, my lord, come to page 6 of the list of dates, 18th March 2019. The respondent issued notice under section 21 of the Arbitration and Conciliation Act. From the letter dated such and such, the plaintiff came to know that the defendant changed its registered office. Subsequent inquiry, it transpired that such change in the registered office took place on 11th March. I showed your lordship the document, the ROC record. Then, my lord, kindly come to 26 March 2019.
105 is your notice. What was the occasion for a notice of arbitration?
They say, my lord, there is an arbitration clause in the agreement.
Where do they say? How did they say?
By this notice?
Oh, respondent issued a notice.
Yes.
Sorry. The respondent issued a notice.
Now kindly come to this notice once, my lord, first. Page 122, volume 1. Huh?
105.
Sorry, page 105. I'm sorry. 105. এটা পড়া যাচ্ছে টাইপড কপি না Page 108, the last paragraph is their invocation of the arbitration. Kindly come to my reply at page 110. 26 March 2019. Addressed to the advocate of the respondent, through whom the notice came. Your client, that is the defendant.
Mr. Bitru, paragraph 8 of your reply.
Yes.
Blackened out here.
Oh, kindly come to page 111, next page.
Next page. Yes.
It's a typed copy. Accordingly, our client has instituted a suit being West number 05 of 20, CS number such and such of 2017 before the Honorable High Court at Calcutta, entitled to claiming a decree for a sum of rupees 1 crore 35 lakhs along with interest against your client. The same is still pending. Several attempts have been made by our client for service of the writ of summons on your client. Despite of such efforts, including substituted service as envisaged under Order 5, Rule 20 of the Code of Civil Procedure, your client has failed and neglected to appear or contest the said suit pending before the Honorable High Court at Calcutta. The said notice is only an afterthought to delay or to make the said suit filed before the Honorable High Court by our client infructuous. No response to this. This is a notice or my lord letter of 26th of March 2019.
And where is the proof of receipt of this?
Admitted.
Admitted.
Yeah. And my lord, the decree was passed, my lord, on 12th of June 2019. Then kindly come to page 7. Decree passed 12th of June 2019. The appellant put the decree into execution by filing execution case number such and such. 14th November 2019, the managing director of the respondent was directed to file affidavit disclosing the assets of the respondent. Notice sent was returned unserved. Then 12th March 2020, by an order, appellant was granted leave to issue advertisement in Central Chronicle and receiver was appointed to take symbolic possession of the whole property. 4th of January 2021, the petitioner came across a public notice in newspaper Doinik Bhaskar wherein part of the property mentioned in item number 1 of paragraph 9 of the affidavit in support of the tabular statement was mentioned for selling the same to a third party. 5th of January, the learned advocate for the petitioner informed one Sudhir Agarwal advocate that any sale, that was the notice issued by Sudhir Agarwal, my lord, the paper publication. The learned advocate for the petitioner informed Sudhir Agarwal advocate that any sale of the subject property will amount to contempt of court. And then, my lord, 25th January 2021, the application was served. Now, kindly once come to their application, my lord, page 91, volume 1. Page 91, kindly come to. Paragraph 2. The page 92, paragraph 2. The petitioner states that the petitioner has come to know of the passing of the ex-parte decree dated 12 June 2019 by the Honorable Justice so-and-so for the first time on 5th of January 2021 in the facts and circumstances stated hereinafter. The petitioner states that the petitioner was never aware of the filing of the present suit before this Honorable Court at any given point of time on or before 26 March 2019. In this regard, the notice under Section 11 of the Arbitration and Conciliation Act 1996 dated 18th March and the reply of the plaintiff's advocate dated 26 March 2019 are annexed here to collectively marked with the letter B. This is the letter, my lord, the service of which your lordships were inquiring. 26 March. However, the then advocate of the petition, from paragraph 4, my lord, kindly take note of the application. However, the then advocate of the petitioner failed and or neglected to take proper steps to follow up the proceeding of the suit pending before this honorable court. Who the advocate? We do not know. Paragraph 5. As far as the petitioner was able to ascertain, the advocate did in fact try to contact several advocates in Kolkata to follow up with regard to the instant suit. However, the petitioner was always informed as and when the erstwhile advocate of the petitioner was contacted in finding out and following up the proceeding of the said suit that due steps are being taken to follow up the above instant suit and to protect the interest of the petitioner. However, it seems now that the said ex-parte decree has been passed on 12 June 2019 in the instant suit and that the petitioner went unrepresented therein. Upon coming to know of passing of the said decree and the pendency of an execution application being EC number 393, wherein two orders dated 14th November 2019 and 12th March 2020 were passed, the petitioner immediately contacted its present advocate. So they are aware of the execution, they are aware of, my lord, the orders passed therein, and they say that they came to know of the passing of the decree on 5th of January 2021. Then kindly come to paragraph 8. Thereafter, the plaintiff's advocate wrote a letter dated 5th January 2021 inter alia informing the petitioner of passing of the decree and pendency of the execution application before this honorable court. But kindly come to page 116. Page 116, letter from Sudhanshu Shekhar Shukla to Sudhir Agarwal. Subject objection with regard to sale of land bearing number such and such at such and such from Cloyne, that is the defendant, situated at such and such. Dear sir, we have been handed over a notice published in Doinik Bhaskar newspaper on 4th of January 2021 at Raipur with instruction from our client to address you as follows. Then my lord, next paragraph speaks about the suit. Then paragraph 4, our client was constrained to put the said decree into execution being EC number such and such. In the said execution case being EC number such and such, the judgment debtor remained unrepresented. The said execution case being EC number such and such was taken up for hearing by an order dated 14th November 2019. The managing director of the judgment debtor was directed to file an affidavit. Then the said application was again taken up for hearing. All these are given. Then my lord, kindly come back to page 93.
Sorry, interrupting. Mr.
Yes.
122 is that Department of Corporate Affairs.
Yes.
Whatever it's called.
Yes.
It says that with effect from 11th March 2019.
Yes.
The registered office of the defendant.
Yes.
Is situated at a particular address.
In front of BSNL office.
Right.
Yes.
This document is dated.
This document. Page 121, my lord, 11th March 2019.
Now look at the cause title. The registered office of the defendant is something else.
Yes. That was the registered office before. That your lordship would find, my lord, at the top. Address of the registered office of page 122. I'm sorry, my lord.
122.
Yes. The original address your lordship will find under serial number 3. Name of the company, then B, address of the registered office of the company, plot number such and such, Udla industrial area. That is the address given in the cost title.
But this was changed to.
That was changed, my lord, during the pendency of the suit and, my lord, after all steps were taken.
I see.
We have brought this also to the notice of the court when, my lord, the decree was passed. That order is there, my lord. I can show you, lordship. It was brought to the notice of the court. But number one, my lord, when the notice was given, as I said, the address was this Udla Industrial Estate. They received the notice. Then, my lord, the suit was instituted with, my lord, this Udla Industrial Estate as the address of the defendant. The writ of summons was, my lord, issued there. The district court, my lord, the service through court, my lord, said they have shifted 3 years back. Now, they know they have shifted 3 years back. Where, my lord, they do not say, number one. And number two, my lord, from this record, it would appear that they did not shift, my lord, in 2018. The shifting took place, my lord, in 2019. After the attempt to service was made. And, my lord, the registered service says that refused. Now, my lord, I do not in fact want to go into that also. My lord, I am strictly relying on, my lord, the second proviso. That you know about this suit. Admittedly, they knew about this suit in March. The decree was passed in June. And what is the explanation? The advocate tried to contact, the advocate did not take steps, my lord. Lordships are aware, my lord. Supreme Court, my lord, for quite some time is saying that no, don't do this. And no particulars of the advocate. My lord, it was hard for me to believe that, my lord, the advocate from, my lord, the Chhattisgarh, Raipur, tried to contact several advocates here and, my lord, nobody responded. No particulars even. Now, kindly come back to their application once again. Page 94. page 94, my lord. Kindly come to page 95. Paragraph 15. That being so, the plaintiff got an order for substituted service through publication of notice in Central Chronicle newspaper, and the whole suit has been tried, heard, and disposed of on the basis of such substituted service sought to be effected by the plaintiff. Copy of orders dated such and such in this regard are downloaded from the official website of the Honorable Court annexed herewith, collectively marked with letter G. The petitioner states that the petitioner did not come across any such advertisement which the plaintiff was supposed to make in terms of the order dated 13th December 2018. Now, well, petitioner is a company. Well, it does not say, my lord, the directors or the persons, my lord, in charge of the company, they did not know. Now, kindly once come to the second volume, page 218. Well, this is the affidavit of service on the basis of the order of 14th August 2018, my lord, giving, my lord, the other advertisement.
This is the amendment application.
And 234, kindly come to, my lord, the next affidavit of service. Pursuant to 13 December. Kindly come to page 2. It starts at page 234. Kindly come to page 236. Paragraph 6, that I on 22nd December 2018 went to serve a letter dated 21st December 2018 with a server copy of the order, along with a legal notice upon the editor Central Chronicle besides such and such, Raipur, to be published in the newspaper, namely Central Chronicle Raipur, and the same was received, acknowledged, and affixed rubber stamp on a copy of the said letter dated 21st December 2018. Receipted copy of the said letter dated such and such. Server copy of the order dated 13th December 2018, passed by His Lordship the Honorable Justice Bhattacharjee. Original notice issued by the Master High Court, original site Calcutta, that on 23rd December 2018, substituted service was advertised containing the prayer in the amended plaint in Central Chronicle. It is part of the affidavit of service, page 244. Yeah, but now this is, my lord, the
any law you want to
yes,
cite?
my lord. Yes. My lord, apart from that, my lord, I don't think that I am required to show any other part of the application, though the decree was passed, my lord, on 12th of June. The prayer, even there was no prayer for even for, my lord, condonation of delay. Now, my lord, on, my lord, Order 9, Rule 13, second proviso. জাজমেন্টে কপি দাও না, 8-এর 2টা দাও। আমার লোক দৌড়ে পালিয়ে গেল। তার আগে একটু চুপ করলেন আমি জানি না, আগে থেকে তো বলা আছে, কেন সেট করা থাকে না আমি তাও বুঝতে পারি না। দাঁড়া, ওরম দিস না। এগারো তিনটা আছে অন্তত, একটা কপি লাগবে আমার তো। এই 11-3 বার করে দিন। Well, at the first judgment I would like to rely on is reported in 2008.
Before you embark.
চাইবো বলো। 2008 volume 2 Supreme Court cases, page 326.
Yes.
Kindly come to paragraph 20. Original rule, Lordship's got that. Original Rule 13 of Order 9 of the court thus provided that when a decree has been passed ex parte against the defendant who satisfied the court that summons was not duly served upon him, the court was bound to set aside the decree. It was immaterial whether the defendant had knowledge about the pendency of the suit or whether he was aware as to the date of hearing, and yet did not appear before the court. The Law Commission considered that aspect of the expression duly served in its 27th report. The Commission said, under Order 9, Rule 13, if the court is satisfied either that the summons has not been served or that the defendant was prevented by sufficient cause from appearing, etc., the ex parte decree should be set aside. The two branches of the rule are distinctive, and the defendant, whatever his position may be in respect of one branch, is entitled to the benefit of the other branch if he satisfied the court that he has made good his contention in respect of the other branch. Now, cases may arise where there has been a technical breach of the requirement of due service. Though the defendant was aware of the institution of the suit, it may well be that the defendant had knowledge of the suit in due time before the date fixed for hearing, and yet apparently he would succeed if there is a technical flaw. This situation can arise, example, where the acknowledgement on the duplicate of the summons has not been signed. There may be small defects in relation to affixation, etc. under Order 5, Rule 15. At present, the requirement of the rule regarding service must be strictly complied with, and actual knowledge of the defendant is immaterial. There are not many decisions which hold that even where there has not been due service, yet the decree can be maintained. Then kindly, my lord, it's law commissions, my lord. Then paragraph 21 also, my lord, law commissions report, kindly come to paragraph 23 directly. It is therefore clear that the legal position under the amended code is not whether the defendant was actually served with the summons in accordance with the procedure laid down and in the manner prescribed in Order 5 of the court, but whether he had notice of the date of hearing of the suit, and two, whether he had sufficient time to appear and answer the claim of the plaintiff. Once these two conditions are satisfied, an ex-parte decree cannot be set aside, even if it is established that there was irregularity in service of summons. If the court is convinced that the defendant had otherwise knowledge of the proceeding and he could have appeared and answered the plaintiff's claim, he cannot put forward a ground of non-service of summons for setting aside ex-parte decree passed against him by invoking Rule 13 of Order 9 of the court. Since the said provision applies to the Dates Recovery Tribunal and Appellate Tribunal, etc., in view of section such and such, both the tribunals were right. Then kindly come to the next paragraph 24. In our opinion, the tribunals were also right in commenting on the conduct of the appellant defendant, that they were appearing before the civil court through an advocate, had filed written statement as also applications requesting the court to treat and try certain issues as preliminary issues. All those facts were material facts. It was therefore incumbent upon the appellant to disclose such facts in an application under such and such when they requested DRT to set aside the ex-parte order passed against them. The appellants deliberately and intentionally concealed those facts. There was no whisper in the said application indicating that the civil court, they were present and were also represented by an advocate. Here, my lord, they were sending letters through their advocates, and my lord, they say that, my lord, the advocates, my lord, tried to contact advocates in Calcutta, several advocates, but nobody was there. Now, my lord, the next judgment I would like to rely on, my lord, is reported in 2011, Volume 3, Supreme Court Cases, page 545. Kindly come to paragraph 12. It is evident from the above that an ex-parte decree against a defendant has to be set aside if the party satisfies the court that summons had not been duly served or he was prevented by sufficient cause from appearing when the suit was called on for hearing. However, the court shall not set aside the said decree on mere irregularity in the service of the summons or in a case where the defendant had notice of the date and sufficient time to appear in the court. The legislature, in its wisdom, made the second proviso mandatory in nature. Thus, it is not permissible for the court to allow the application in utter disregard of the terms and conditions incorporated in the second proviso herein. Then 13, my lord, kindly come to sufficient cause is an expression which has been used in a large number of statutes. The meaning of the word sufficient is adequate or enough, inasmuch as may be necessary to answer the purpose intended. Therefore, the word sufficient embraces no more than that which provides a platitude, which, when the act done, suffices to accomplish the purpose intended in the facts and circumstances existing in a case, and duly examined from the viewpoint of a reasonable standard of a cautious man. In this context, sufficient cause means that the party had not acted in a negligent manner, and there was a want of bona fide on its part in view of the fact and circumstances of the case, or the party cannot be alleged to have been not acting diligently or remaining inactive. However, the facts and circumstances of each case must afford sufficient ground to enable the court concerned to exercise discretion, for the reason that whatever the court exercises discretion, it has to be exercised judiciously. Then, my lord, it's not required. Then, my lord, I would like to rely on two decisions, my lord, on sufficient cause also. The first one, my lord, is reported in 2002, volume 7, Supreme Court cases, page 531. দেখি ও বুলেটিং এ লেখা আছে এই kindly come to paragraph 5. Speaks of Order 9, Rule 13 of the Code of Civil Procedure, insists that the applicant must satisfy the court two conditions: summons was not duly served, and that the appellant was prevented by any sufficient cause from appearing before the court. Then, my lord, kindly come to paragraph 6, my lord, the last sentence of paragraph 6. We are also of the view that it is inherently probable that the publication in the local daily Achoron, which is widely circulated in the area, would have constituted a sufficient notice to the defendant. Then 7. Before the trial court, the stand taken by the plaintiff was that the defendant had knowledge about the suit filed by the plaintiff, and they had sufficient time to appear and answer the plaintiff's claim. But they did not appear, and the application had been filed with the intention to cause delay. Be that as it may, we are of the view that the publication of the substituted service in the local daily instead of such and such is a mere irregularity in the service of summons. Then, my lord, kindly come to one more paragraph, my lord, paragraph 10. Then, my lord, paragraph 9 deals with the second proviso. Then paragraph 10, it is nobody's case that the postal address of the defendant are not properly addressed, and therefore the registered summons could not be served. It is also nobody's case that the registered summons are not prepaid and not duly sent. In fact, the registered summons bearing receipt number such and such were issued is borne out from the records. Here also, my lord, as I have submitted before your lordship, that when The summons and my lord was sent. In fact, my lord, summons of the amended plaint also. The registered office was still at the old address. তেরো চোদ্দটা দিন দেখাবো নাকি একবারে লয়ারের গ্রাউন্ডে চলে যাবো Well, the next one I would like to rely on is reported in 2013, volume 14, Supreme Court cases, page 81. SCC 81. Kindly come to paragraph 11. The expression sufficient cause should be given a liberal interpretation to ensure that substantial justice is done, but only so long as negligence, inaction, or lack of bona fide cannot be imputed to the party concerned. Whether or not sufficient cause has been furnished can be decided on the facts of a particular case, and no straitjacket formula is possible. It is settled legal proposition that law of limitation may harshly affect a particular party, but it has to be applied with all its rigors. When the statute so prescribes, the court has no power to extend the period of limitation on equitable ground. A result flowing from a statutory provision is never an evil. A court has no power to ignore the provisions to relieve what it considers a distress resulting from its operation. The statutory provision may cause hardship or inconvenience to a particular party, but the court has no choice but to enforce it, giving full effect to the same. The legal maxim, which means the law is hard but it is the law, stands attracted in such a situation. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a statute. Then 13 miler statute of limitation, it goes into. Then kindly come to paragraph 15. The law on the issue can be summarized to the effect that where a case has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In case a party is found to be negligent or for want of bona fide on his part in the facts and circumstances of the case, or found to have not acted diligently or remained inactive, there cannot be a justified ground to condone the delay. No court could be justified in condoning such an inordinate delay by imposing any condition whatsoever. It goes into, my lord, condonation of delay. I am on sufficient cause only, that if you know everything and you don't take steps, you are not entitled to. My lord, there are two decisions, my lord, lawyers ground, my lord. May I give references?
Refusal is good service to these have been watered down. Rafiq's was the original that,
my lord, the last
litigant
one
should not suffer for lawyer's default.
No, that has been watered down.
Yes.
That was 1981 possibly. Then, my lord, 1993, two Supreme Court cases, my lord, 185. Paragraph 8, my lord, only one paragraph. May I show our SCC online about Kurak?
On PMMC, there was a Supreme Court case substantially watering down what Rafiq had said. A TMMC, this one.
Well, let kindly come to paragraph 8 of the judgment reported in 1993, two Supreme Court cases, page 185.
Paragraph?
8. The advocate is the agent of the party. His acts and statements made within the limits of authority given to him are the acts and statements of the principal, that is the party who engaged him. It is true that in certain situations the court may, in the interest of justice, set aside a dismissal order or an ex parte decree notwithstanding the negligence and or misdemeanor of the advocate, where it finds that the client was an innocent litigant, but there is no such absolute rule that a party can disown its advocate at any time and seek relief. No such absolute immunity can be recognized. Such an absolute rule would make the working of this system extremely difficult. The observations made in Rafiq must be understood in the facts and circumstances of this case and cannot be understood as an absolute proposition. Well, there, my lord, this rustic villager, all this came in. As we have mentioned here in above, this was an ongoing suit posted for final hearing after a lapse of 7 years of its institution. It was not a second appeal filed by a villager residing away from the city where the court is located. The defendant is also not a rustic, ignorant villager, but a private limited company with its head office at Calcutta itself and managed by educated businessmen who know where their interest lies. It is evident that when their applications were not disposed of before taking up the suit for final hearing, they felt piqued and refused to appear before the court. Maybe it was part of their delaying tactics as alleged by the plaintiff. Maybe not. But one thing is clear, they chose to non-cooperate with the court. Having adopted such a stand towards the court, the defendant has no right to ask its indulgence. Putting the entire blame upon the advocate and trying to make it out as if they were totally unaware of the nature or significance of the proceeding is a theory which cannot be accepted and ought not to have been accepted. Now, my lord, this has been followed, my lord, and a very recent judgment reported in 2024 SCC Online Supreme Court 3380.
Rafiq was 81 Supreme.
81.
Paragraph 10.
My lord, sorry, my lord, I don't have, my lord, the
Here's the citation
2024 I shall give, my lord, immediately after, my lord, the 2024 SCC Online Supreme Court 3380. May I read out, my lord, the paragraph? Paragraph 10. It appears that the entire blame has been thrown on the head of the advocate who was appearing for the petitioners in the trial court. We have noticed over a period of time a tendency on the part of litigants to blame their lawyers of negligence and carelessness in attending the proceedings before the court. Even if we assume for a moment that the concerned lawyer was careless or negligent, this by itself cannot be a ground to condone long and inordinate delay, as the litigant owes a duty to be vigilant of his own right and is expected to be equally vigilant about the judicial proceedings pending in court initiated at his instance. The litigant therefore should not be permitted to throw the entire blame on the head of the advocate and thereby disown him at any time and seek relief. I shall give the copies, my lord. And my lord, refusal is good service, my lord. That is the other point, my lord. After all, my lord, registered post shows that, my lord, it was two, at least two, shows that, my lord, those were refused. My lord, that is reported in 2017, volume 5, Supreme Court cases 737. 3 paragraphs, my lord, paragraphs 13 to 15. May I hand over copy, my lord? Do not want to waste your lordship's time.
Shall we hear Mr. Ghosh?
And my lord, so far as, my lord, the point maintainability, my lord, we are covered by Kimji.
Maintainability of what?
Of the appeal, my lord. Is
he arguing that? No.
Lordship, my lord, those are my responses.
I come? Yes, I don't want to make a piecemeal argument. I will finish on that. You not want me? I can factually. I'm ready.
No. No piecemeal.
Yes, but factually I'm ready.
When?
It's in the next week.
It has boiled down to a very short compass now, Mr. Ghosh.
But may I indicate? Then may I indicate for 5
Let
minutes?
us indicate that will be easier for you.
May I indicate?
Let us indicate it will be easier for you. The two refusals explain that. More importantly, 26th of March, 2019, you receive reply to your notice under Arbitration Act, wherein clearly it is stated that a civil suit has been filed with the suit number and the claim. Your only explanation is your advocates betrayed you. Difficult. If that is your only explanation, it's difficult. Come back.
No, now the question is, all the answer would lie in the fact that the factum of filing of the plaint itself is a fraud. I will show. Your Lordship was looking at that arbitration notice. The memorandum which is annexed to the plaint has a clear arbitration clause. I will show what the twist has been given to. That's a different aspect. What has happened is, even the learned judge who has passed the decree has disbelieved them because they tried to hoodwink the court. Why? The first suit
When will
withdrawn.
you come back? No piecemeal. No
Yes,
piecemeal.
Tuesday.
Mr. S.N. Mitro, a learned senior advocate representing the appellant, concludes his argument. Paragraph. Mr. Rupak Ghosh, a learned senior counsel representing the respondent, seeks a little time, as requested by him, let this matter be listed once again on May 13. Appeal from order. As the first item under the heading appeal from order.
But instead of 13th, can it be 16th? I'm being told. I'm sorry. I'm grateful. 13th it is.
Substantially, it's better that I argue on Tuesday and finish.
Finish it off, yes.
Grateful.
Only thing that I'm seeking leave. I will not even want to delay the hearing, my lord. It's a part of the records. The thing that they have not appended to the paper book is, my lord, an evidence that was recorded by my learned friend before the decree. That evidence is a part of the records. I will try to give production also, and I'll give
production
and give copy also.
Item number 28.
My lord, in this matter, Mr. Jishnu Shah is appearing for the appellants, my lord. Since he is out of station, I am praying for not this week.
It has the note.
But I am appearing on behalf of this.
What do you want? Not this week.
Not this week.
Not this week. Without a form.
On the prayer made on behalf of the appellant.
On behalf of the appellant.
Or let this matter stand adjourned for the week.
Grateful, my lord.
Item number 30.
My lord, I'm for the appellant, my lord. On the last occasion, my lord, they directed the official liquidator to be present personally, my lord.
I'm for the official liquidator.
A very short matter, my lord. Already a stay of the impugned order has been granted on 3rd October 2023, my lord.
Oh.
Page number 44 is the order, relevant order, my lord. Passed on 3rd October 2023 by a learned coordinate bench, my lord. 44.
What is the matter about?
My lord, in this order, my lord, there was a direction to stay of the impugned order and 50% payment of the admitted dues of the workers. of the appellants. But that has been done. Now, presently, this application ACO 3 has been filed by the ex-workers separate from the appellants. 9 workers, their claim are also admitted. They are in the same footing as the appellants. I'm praying that the same liberty will be given to the workers, my lord. 50% payment of the admitted dues may be given to them in terms of the order dated 3rd October.
I see. 3rd October 2023.
Yes, my lord. Page 44.
Lordship, I beg to differ with my learned friend. My humble submission is they are not in the similar footing with the appellants.
This order directed payment of 50% of each worker.
Admitted dues of the appellants.
And the present,
and they are not the appellants, they are the applicants. My lord, they have filed. They
are also workers of the
ex-workers.
company in liquidation.
Yes, my lord. They have also received that their dues are admitted. I have annexed the pages, my lord. Page 14, it is started that their dues are admitted. Claim allowed, my lord. It is appearing from their records only.
Lordship, their dues are although admitted, but they are in the capacity of unsecured creditors, not as
The
workmen.
appellants were also unsecured creditors. The appellants were also ex-workers. There is nothing other than I'm seeking. I'm seeking only the same liberty that was granted through 3rd October 2023 order, my lord.
Also, Lordship, the appeal was from an order of the learned single bench, whereby the matter was directed to be transferred to NCLT.
That order has been stayed.
The appeal is from a transfer order.
Yes, madam.
Official liquidator shouldn't oppose this. They were not opposing on the.
I humbly beseech that the applicants should seek their relief on a in the CP itself, in the company
CP?
petition itself.
Sorry, what?
Lordship, this appeal does in this appeal their claim is claim does not lie because they are not.
Appeal is preferred by whom? Appeal has been preferred by whom?
Appeal is preferred by the appellants who were ex-workmen of the company, and their admitted claim 50% of their admitted
Kumar
claim,
Banerjee.
50% of their admitted claim has been disbursed from the official liquidator's office. But in this application, the applicants are not applying as ex-workmen; they are applying as secured creditors.
As
unsecured creditors. I beg.
No, my lord. I have clearly stated in paragraph 2 of the application that I am the ex-workers and ex-employees of the company.
Madam, if they are ex-workmen of the company in liquidation, they also get the same benefit what the appellants got.
Lordship, kindly come to their paragraph number 3 in page 8.
এই কি দিচ্ছে বলো তো?
ACO 3 of 2024.
ACO?
3.
এটা ACO 1.
ACO 3, ACO 3.
The admitted claims are from the deposits they have made in the company, not from their wages, not from their due wages or salaries.
I will kindly see page 14 then. This is the admitted document. The claim has been admitted. And my lord, page 17 also.
Yes, the
These are
claims
issued by the official liquidator.
creditors.
These are issued by the official liquidator, my lord. And this same scenario was for the appellants also. My lord can confirm it from ACO 1 also.
Is the official liquidator here in court?
Lordship, he was here, but he had to run urgent to the national company law tribunal.
We had directed him to be present in court,
He was here, Lordship.
and without leave he
And on the
went away.
first call, he was not there.
Shall we send the police to get him?
Lordship, kindly consider the situation. He will be here.
Ask him to be here at 2 p.m.
May I humbly ask for to fix it at around 3 p.m. because I won't be able to represent him at 2 p.m.
Why? Where will you be?
in court number 9, Lordship. Lordship, I'll
A
be
very
assisting
innocuous
Lalit
pair
Singh.
has been made, my lord. I am only seeking the liberty.
Let the OL come, sir. Let the OL come. Let us ask him. You fix nahi to ajke?
At 3:30, there is a matter fixed, my lord.
3:15. Come back at 3:15.
Much obliged.
Deeply obliged, my lord. Interpon.
হ্যাঁ সেই আমি এদের উপর বেশি চেঁচাতে পারবো না আমরা। হ্যাঁ 9
Item 32.
Lordship, in item 32 and 31, I'm appearing on behalf of the respondents. Lordship has adjourned item number 31. Both are connected.
Oh, I see.
Your Lordship,
এই তো একই তো দেখছো তো C&D Limited. We have adjourned it till 14/5. 14/5. এটাও করে দাও।
one small prayer. Can it be adjourned after, like, kept after the vacation?
No, not ex-parte like this. You should have said that in their presence.
First call, Your Lordship. You were not present.
Talk to them, come back tomorrow, tell us, we'll adjourn it.
Your Lordship. Great.
Item number 34.
I appear for the appellant, my lord. My lord, would it be my lord's pleasure to take it up in the second half, my lord? I'm led by Mr. Chaudhary.
Respondent, my lord. The next week.
Next week. Not this week.
Second half, acha, very
Grateful.
grateful.
Item number 37.
I appear for the appellant.
Who is for Balaji?
I'm for the respondent, Your Lordship.
Okay. As far as 22 is concerned, your lordship is that is part heard already. I'm sorry, I reached the court.
Would you rather do that at 2 p.m.?
Whichever.
How?
This is also a heavy matter.
Heavy
but
matter.
I can start now.
Yeah,
Mr. Shah's there. Last time they took time.
Then Mr. Ghosh, we'll hear you. Come back at 2:30.
2:30.
And then we'll hear you for the next 45 minutes. At 3:15, we have called the official liquidator, and 3:30 we will go.
2:30 for the that item 22.
Better you finish that off.
Your lordship just passes this over today.
Yes.
I'll take it up.
Yes. আমরা উঠছি এখন ডাকো। है भाई
22 compensation or damage, but no loss has been proved. This was my first point. And for that, I had relied on that Supreme Court judgment of Unibro, Justice Dipankar Datta's judgment. I just placed that, where it's given what has to be proved in order to have a claim for damages. First, you prove the breach, then you show the resulting loss of the breach, then you quantify it. So simply because it's a my lord, without going into that evidence of loss of profit, loss of business opportunities, etc., and that followed a 2004 decision of Sarvesh Chopra, which I have also relied on. It's quoted in that judgment. So that was my first point. Now, the second and the third points are, my lord, that one is that there is no, it is the award is not reasoned, and no reasons have been given, and the purported reasons, which were the allegedly stated in paragraphs 8 to pages 8 to 11 of the award, that's the pre-going, which is referred to in ongoing fashion, my lord. That claim, my lord, according to me, are not reasons. They are not reasons. And the third is that it is based on no evidence. Now, one of the points that did not hold favor with the learned judge below was that this is the 1940 Act, and he was under the impression that reasons are not required. I haven't placed the impugned judgment. I'll show that last, my lord, but these are the points I should be able to complete it quickly. Well, so as far as this is concerned, whether in the 1940 Arbitration Act, whether reasons were required or not. Now, it is true that in the 1940 Act envisaged a non-speaking award, where no reasons were required and you could not go into the thought process. Yes. But if the arbitrator has chosen to give reasons, then it is open to scrutiny by the court. So for this basic proposition, I want to cite one decision. This one. Where's mine? This is, of course, from the Madhya Pradesh judgment. It's reported in SCC online. 1979 MPLJ, page 208. I'll give you a copy. They don't copy it. I'll just. Here, the award, if my lord comes to paragraph 1, the award had been set aside by the district judge, and the appeal was preferred from that by the state, and that appeal was also dismissed. So this is the factual part of this case. My lord comes to paragraph 3, that's at page 210. And the third line of that paragraph, I'm reading, fourth line. He then filed his objection under section 30 and 33, contending that the award is vitiated on the following grounds. Various grounds are given. One of the grounds I want to highlight is ground number 4. No, I'm sorry, 3 and 4. The arbitrator has further misconducted himself in failing to decide the main dispute as to what is the rate payable in respect of item 11. And 4, the award is vague and cryptic, and it is very difficult to know the findings of the arbitrator, what the findings of the arbitrator are in respect of the claims made by the respondent. So my respectful submission applying this claim or this objection, as it were, to our award, and it is very difficult to know, because he has said, I have perused the correspondence and the state could have removed some hindrances. That's all he's found. What the hindrance was, what the removal entailed, well, nothing is written. That's page 8 to 11. So here also it was very difficult to know what the findings of the arbitrator were. Then, well, I'm not reading this. This is the case of there. Now, if my lord turns to the next page, 211. For the principle of law, because it's paragraph 4 begins with, under section 30 of the Act, an award shall not be set aside except in one of the following grounds. Then the grounds of 30 and 33 are set out. Now, if my lord comes to the citation in Bungo Steel Furniture versus Union of India. My lord has that, page 211. Here the principle is set out very well. The Supreme Court has laid down just at the bottom half of the page. This is the principle I want to rely on. If an arbitrator, in deciding a dispute, does not record his reasons and does not indicate the principles of law on which he has proceeded, the award is not on that count vitiated. It is only when the arbitrator proceeds to give his reasons or to lay down the principles on which he has arrived at his decision that the court is competent to examine whether he has proceeded contrary to law and is entitled to interfere if such error in law is apparent on the face of the award itself. So, my lord, since here he has chosen to go into the reasons, then, my lord, the court was competent to look into it. So, as far as the impugned order is concerned, in that aspect, it was incorrect. The learned judge has also held that the reasons were sufficient. That I'll come to later. Now, my lord, if my lord sees, there's one more point in this matter that's important. Now, next paragraph. The Supreme Court in the Union of India versus J.N. Mishra has held the arbitrator is not bound to give an award on each point. He can make an award for the whole case. An arbitrator may award one sum generally in respect of all the money claims submitted to him, unless the submission requires him to award separately on one or more. Therefore, it is settled law that an arbitrator need not give reasoned award, and the award cannot be set aside because it is vague and cryptic. In dealing with an application under Section 30, the court is not sitting in appeal over the decision of the arbitrator. It is not open, this is the general principle. It is not open to the court to speculate when no reasons are given by the arbitrator as to what impelled the arbitrator to arrive at his conclusion. But if the arbitrator does record reasons for his conclusions, then it is open to the court to examine whether the arbitrator has proceeded contrary to law, and the court is entitled to interfere if there is error apparent on the face of the award. However, Supreme Court in Allen and Berry versus Union of India has held, as the parties chose their own arbitrator, they cannot, when the award is good on the face of it, object to the decision either in law or facts. Therefore, even when the arbitrator commits a mistake, either in law or fact, in determining matters referred to him, but mistakes does not appear on the face of the award or in a document appended to or incorporated in it, so as to form a part of it, the award will neither be remitted nor set aside, notwithstanding the mistake. Mere reference to the contract in an award is not held to be held as incorporating it. Therefore, though the court is not entitled to go beyond the award and to find out what could have been the reasons for giving the award, but if document is appended to the award or is incorporated in it, so as to form a part of it, then it will be open to the court to look into these documents. And the test is that does the arbitrator come to the finding on the wording of the contract? If he does, he can be said to have impliedly incorporated the contract or the clause, whichever may be the case. Then it goes on to say the arbitrator is not bound by the rules of evidence. Then if my lord comes down to about 6-7 lines in paragraph 5, an arbitrator is not bound by the technical and strict rules of evidence, but he must not disregard the rules of evidence, which are founded on the fundamental principles of justice and public policy. So evidence also has to be looked into and he cannot be disregarded. Then it goes on. So then the other important aspect of this decision which will help me, my lord, is paragraph 6. So initially it says in this particular case, my lord, the question before the arbitrator, what was the rate of item 11? Now, the petitioner said one rate, the respondent said another rate. The arbitrator came to another rate via media. Now, that was not permissible under the 1940 Act. So, this paragraph 6 elaborates that. And my lord will recall that in our case, the arbitrator for different claims has given 75%. I feel 75% is correct. One, they have given 33% of what is claimed is given, and in one, 50%. So he has apportioned it, not what I said, not what he said, but in his own view. And that is not permissible. And it was on that ground this award, particular award, was set aside, and the decision was upheld. And may I place paragraph 6? However, we are of the opinion that the findings of the learned district judge have to be affirmed, as the arbitrator has failed to arbitrate on the main dispute which was referred to him. That is, what is the rate payable for item number 11. Recently, the Supreme Court in Odisha Mining's case has held, when an agreement is filed in court, an order of reference is made under section 20, then the claim as a result of the order of reference is limited to a particular relief, and the arbitrator cannot enlarge the scope of the reference and entertain fresh claims without the order of reference from the court. In the present case, the arbitrator was required to give his findings by accepting either the interpretation of the respondent or the interpretation of the department regarding rate of payment of item 11. It was perfectly permissible to the arbitrator to give a lump sum award for all the claims without separately mentioning the amount awarded in respect of each claim. The award mentions that on examination and consideration of the statement of parties and the evidence produced, the claimant should be paid a lump sum of rupees 31,500 against his claims 1 and 3. With the award was appended the record of proceedings of the arbitrator. In the proceedings dated such and such, the arbitrator calculated how the figure of 31,500 was arrived at. Out of this, 1,500 was paid towards claim 3, and for claim 1, 30,000 was awarded. This figure he has arrived at by multiplying the quantity of work done in respect of item 11 by 30, which means the arbitrator has given the rate of rupees 30 for item number 11. Since these proceedings were incorporated in the award, it is open to this court to look into these proceedings and find out how the amount of 31,500 had been awarded by the arbitrator. The arbitrator seems to have made a via media between the claim of the respondent and the stand taken by the state. The arbitrator should have strictly confined himself to the question referred, that is, either to accept the interpretation of rate number 11, rate of item number 11, or put by the respondent or put by the department. He could not have substituted an entirely new rate which was not stipulated by the parties in the contract. We are therefore inclined to agree with the findings of the district judge that the arbitrator failed to decide the main dispute which was referred to him, that is, what is the rate of work of item 11, and whether the rate has to be calculated by adding rates of items 9 and 10 or item 11 is independent. Then, my lord, another decision is of, I think this is Rajasthan court is cited. May I just place this because the last portion will again assist me. The real dispute between the parties that were referred to the arbitrator was the applicability of the correct rate for the job done by the contractor. It was not that the parties only wanted the arbitrator to determine the sum payable by one to the other. Indeed, there was no serious dispute between them regarding the actual amount that may be payable once the question of rate was adjudicated. The award did not show what the decision of the arbitrator had been regarding the rate that was to be applied to the various items of work. It could not be concluded that by the necessary intendment, he decided the question of rate. Had he accepted the claim of one party or the other in toto, it would have been possible to infer that by implication, he accepted the rate claimed by the party. But the figure awarded by the arbitrator could not be worked out on either of the two rates claimed by the respective parties. The arbitrator had failed to decide the main point of difference referred to him, and the award produced by him was therefore incomplete and defective, and on that ground, and hence could not be sustained. And similarly, this was not given. So two things that come from here, my lord. One is that if he has given reasons, the court can go into those reasons. And secondly is that he had to decide on the basis of the contract and not by a way of a via media, which, if my lord reads the award once again, will find that there is actually no reason sustaining the amounts, why it was 50%, why it was 75%, etc. So that part I've placed. Now I'll just want to cite one or two decisions, one decision really, on what are reasons. Now, and whether giving, yes. No, I've got. I think I've got. You give the other side. No? You give the other one. The other one. So, sorry, no, I'll have to take it back. Right, I can't find. Well, this decision, division bench set aside an award by saying there was no reasons. Paragraph 18 to 21, if I may just place those. I'm not going into the other facts. Now, paragraph 18. Actually, paragraph 17, otherwise the other way will not be apparent. Paragraph 17 onwards, I'm placing. There are two approaches open for the purpose of assessing the award. Now it is clear and undeniable that the arbitral award is a substantial reproduction of the notes of arguments filed by the contractor at the conclusion of the reference, in the narration of facts, in most of the reasoning pertaining to the discussion on issues, and to a significantly larger extent while dealing with the heads. The easier option is to bludgeon through the process and hold the arbitral award to lack the fundamental element of adjudication that ought to be reflected in such a document. Now, the allegation was that Justice Jain, Bahubulal Jain, had cut paste our arguments. Though that time there was no cut paste. At the time when the award was done, it was the computers were not so rampant. But this was one argument. However, in adopting such a route, it would be an underlying suspicion of misconduct which is at play, though there is no direct evidence other than what is reflected in the award in this regard. Again, the justification for this easier approach may be that the acts of misconduct are not carried out openly upon invitation to the other side for there to be any direct evidence in this regard. So it was not considered. Now the other approach. The other way of dealing with the award is to treat it at face value and to assess it on the less unpleasant ground of lacking in reasons. The Act of 96 commands that an award that is passed in any arbitral proceedings governed by the statute ought to be reasoned. Reasons are the links between the fact and the conclusion, and they reveal the application of mind to matters in issue and trace the journey from the narrative to the directive. The reasons are the lifeblood of any acceptable process of adjudication, and as to whether an award or the order is reasoned or not, it depends much more on the quality than on the quantity of words expended. On a set of facts where the conclusion or the inference is self-evident, elaborate reasons may not necessarily justify the conclusion. But where even if the factum is established, the quantum of compensation requires detailed attention, and the reasons furnished call for a stricter scrutiny. Reasons are the plinth on which the edifice of conclusion stands, and the stronger the base, the more difficult it is to dislodge these conclusions. Then the heads of claim are referred to is not relevant if my lord comes to paragraph 20. Well, the evidence is referred to generally to the witness's evidence, but no particular questions. Even in our case, there was no evidence only. So it really doesn't matter. 20. The first two heads of claim pertaining to loss and damage and repair and rectification are referred to in the discussion on the seventh issue. It is evident from such discussion that a calculation sheet pertaining to loss and damage allegedly suffered by the contractor was furnished by the plaintiff's second witness, PW2. In dealing with the basis for claim and factum aspect, the arbitrator referred to, in inverted commas, this is very similar to our award, so I'm placing it, carefully considered and examined records, papers, pleadings, evidence, and documents pertaining to the claim, and observed that against the compensation sought for 492 days, in respect of a period aggregating to 108 days, I have some doubts as to the proof and maintainability of the claim, and as such, compensation for the aforesaid period of 108 days is disallowed and not granted. So no reasons were given why 108 days were not allowed out of the 492. And in our case, it's why 25% was not allowed and only 75% was given. Even though it's against me, it could have been 0% and 99.99%. Then the arbitrator then sought to refer to the relevant clauses of the contract, but merely set out pages from the papers filled in the reference over 2 pages, the entirety of which was copied from the notes of argument. The cryptic references, even if it is disregarded that the same were copied from the notes, do not convey any sense and are expressed in the following terms. So these documents were referred to in this manner. Then the arbitrator has based his subjective finding on the issue, on the oral evidence, and has referred to several questions by numbers without indicating which part of the answer or for what purpose or to what extent helped in the subjective assessment of the arbitrator on the justification of such head. So, so basically, even in our case, my lord, if your lordship peruses the award over and over again, you will not find on what particular allegation কোন প্যারাগ্রাফ গুলো আমি তো পড়ে নি, তুমি দেখো ইট ইজ রেলেভেন্ট। দেয় না, দেখাবো। মানুটা ছিল না লিস্ট, না লিপ সার্ভিসটা কথা বলেছে। বানোটা কি আছে? Paragraph 23. Paragraph 22, I'll just show one line. The claim was for 10 crores, 10.21 crores, which was allowed to the extent of 7.97. I'm just giving my lord the figures. Paragraph 22.
So both the parties had challenged the award.
In
your case, that case.
In that case, yes. That was also mine. Yes, that was both parties had challenged. No, the petitioner had not challenged. It was from another order. There was 2 other appeals.
I see.
Both that. So, my lord, the paragraph 22, just the last line I told my lord, 7 crores out of 10 crores was given. Then the last sentence I'm reading, the claim on account of repair and rectification to the extent of 36 lakhs, of which 25 lakhs was allowed, but on a completely subjective basis without any objective ground made in support thereof. So this is another ground that it cannot be completely subjective. Now, the next paragraph is important because that 23, yes. It is undeniable that there is an element of subjectivity which is always involved. But such subjectivity has to stand on some objective footing. And without the fundamental premise of the quantification or arithmetical basis, therefore being indicated, the mere lip service that the arbitrator pays to having read the pleadings, evidence, and documents would not suffice for reasons that the statute commands the arbitrator to furnish. This line is very telling, my lord, because he has every time said, I have considered the letters, correspondence, etc., and I find that this thing. So these are not reasons. They are not the link between the fact and the conclusion, or they are not the plinth on which the award is standing. Then well, I was just relying on those 3 lines in paragraph 23. Thereafter, my lord, there are other grounds also that the defense was not referred to, etc. I'm not placing that, but I really wanted to place this judgment to say what are reasons, and even if these are purported reasons, they do not amount to reasons as legal reasons, as it were, which is required under the law, because it is not based on any objective scale or any evidence, if I may put it that way. I'm not placing the other paragraph, but this was the sum and substance of it. Now, this has been followed in Banu, other cases. I'm not citing that, but it follows McDermott's case, 2011 Supreme Court. The definition of reasons in that 2006-11. I just want to cite that definition. It's McDermott versus Burn Standard, 2006, 11 SCC 181, under paragraph 50 and 51. 50 though. No. See that which paragraph I cited in the question I was looking. Quickly, McDermott. It's in your WhatsApp. But paragraph 56, I'm sorry, paragraph 56.
55.
55 says that now reasons has become a mandatory ground under 1996 Act. But I've already shown in the 1940 Act, because this was also, I think, relied on by my learned friend in the trial court, 55. Another important change which has been made by reasons of the provisions of the 96 Act is that unlike 1940, arbitrator is required to assign reasons in support of the award. A question may invariably arise as to what is meant by a reasoned award. Then 56. Bachawat's law of arbitration is quoted. Reason is a ground or motive for a belief or a course of action, a statement in justification or explanation of belief or action. It is in this sense that an award must state reasons for the amount awarded. The rationale for the requirement of reasons is that reasons assure that the arbitrator has not acted capriciously. Reasons reveal the grounds on which the arbitrator reached his conclusion, which adversely affects the interests of a party. The contractual stipulation of reasons means, as per Pozzer and Mills arbitration, proper, adequate reasons. Such reasons shall not only be intelligible, but also be reasons connected with the case which the court can see is proper. Contradictory reasons are equal to lack of reasons. And these lines, though quoted from some foreign textbook, proper, adequate, and intelligible. This is repeated by Supreme Court in a later judgment. That just giving reasons is not good enough. They have to be proper, adequate, and intelligible. You must understand why and what went wrong. Then, my lord, that thing is quoted again. Reasons are the links between the materials on which conclusions are based and the actual conclusions. A mere statement of reasons does not satisfy the requirements of 31(3). Reasons must be based upon materials submitted before the arbitral tribunal. Tribunal has to give reasons on consideration of the relevant materials, while the irrelevant may be ignored. Statement of reasons is mandatory requirement unless dispensed with by the parties. Then 59, paragraph 59. And it talks about patent illegality, but now the law of patent has been incorporated in the act itself. Patent illegality will include contrary to contract, contrary to law, etc. It will come under that. Then 59, patent illegality must go to the root of the matter. Public policy violation indisputably should be so unfair and unreasonable so as to shock the conscience of the court. So this test still remains about the shocking of the conscience. Where the arbitrator, however, has gone contrary or beyond the express law of contract or granted relief in the matter is not in dispute, would come within the purview of 34. However, we consider the applicability of the aforesaid principles while noticing the merits. I am really relying on the two paragraphs for reasons. What are reasons? Now, yes. The other decision or just a few lines from there. This is the next decisions reported in 2019, 20 SCC, page 1. Diana Technologies versus Crompton Greaves. And just paragraph 1, just for the introduction. The question involved herein revolves around the requirement of a reasoned award and the cautionary tale for the parties and arbitrators to have a clear award, rather than have an award which is muddled in form and implied in its content, which inevitably leads to wastage of time and resources of the parties to get clarity, and in some cases frustrate the very reason for going to arbitration. Then, the paragraph 2 says that the main claim 2, is for payment of compensation for losses suffered. So this was also a damage claim. Paragraph 2, the last line I've just referred to. Now, if my lord comes to paragraph 26. Though I'd say that 26 really refers to the 96 Act, but just for completeness, I'm showing that I'll really rely on 34. But the same principles will apply. 26. Having established the basic jurisprudence behind section 34, we must focus on the analysis of the case. The primary contention of learned counsel appearing on behalf of the appellant is that the award by the tribunal was perverse for want of reasons. Necessity for providing reasons is provided in section 31. Then it goes on why reasons are mandatory right up to section 34. I'm relying on paragraph 35 for reasons which will apply also to the 1940 Act. 35. When we consider the requirement of a reasoned order, 3 characteristics of a reasoned order can be fathomed. They are proper, intelligible, and adequate. This is like what was stated in Bachawat's book also. Proper, intelligible, and adequate. If the reasonings in the order are improper, they reveal a flaw in the decision-making process. If the challenge to an award is based on impropriety or perversity in the reasoning, then it can be challenged strictly on the grounds provided under section 34. If the challenge to an award is based on the ground that the same is unintelligible and the same would be equivalent of providing no reasons at all. Coming to the last aspect concerning the challenge on adequacy of reasons, the court, while exercising jurisdiction under 34, has to adjudicate the validity of such award based on the degree of particularity of reasonings required having regard to the nature of issues falling for consideration. the degree of particularity cannot be stated in a precise manner, as the same would depend on the complexity of the issue. Even if the court comes to the conclusion that there are gaps in the reasoning for conclusions reached by the tribunal, the court needs to have regard to the documents submitted by the parties and the contentions raised before the tribunal, so that the awards with inadequate reasons are not set aside in a casual and cavalier manner. On the other hand, ordinarily unintelligible awards are to be set aside, subject to party autonomy to do away with the reasoned order. Therefore, the courts are required to be careful in distinguishing between inadequacy of reasons in the award and unintelligible awards. Now, I would say this counts as both. This not only inadequate, but it's also unintelligible in the sense that he has proportioned it according to his whims and fancies. He's proportioned the claims. And I've placed those paragraphs in the award. I'm not doing it again. And as far as not considering the evidence on record, the ground of perversity, that I'll just cite one decision, Sang-yong, just one paragraph. But that also refers to Associated Builders case, the 2015. Oh, it's been set out. No. It asks associated us. Well, then formally I'll just cite that associated also. 2015, 3 SCC, page 49, paragraphs 32 and 33. No, associated. Wait. Isn't it set out in this?
Yes, it is set out.
And if it is set out, then I won't cite it separately. It's referred to these paragraphs, but may I just place these copy associated? And basically, associated recognize perversity, that is, the lack of evidence or ignoring vital evidence, as a ground for setting aside. And that ground is also available in 1940. That is my submission, my lord. So, please. But while they are finding it, may I just place that one paragraph? And I'll hand over this copy. If my lord allows me to just read it, act a copy, judge.
Paragraph?
Paragraph 31 and 32 rather, just 32 and 33, sorry. A good working test for perversity is contained in two judgments. And one of these two decisions were under the 1940 Act, really. I'll hand over this. This paragraph 32 and 32 and 33. I was saying young though. So if the finding is based on no evidence or it is ignoring the vital evidence on record, then these two grounds, I'll show my lord that this thing. Oh. Now the next decision, which also follows this, is 2019 15 SCC, page 131, Sang-yong versus National Highway Authority. That I'm relying on paragraph 41. It's a repetition of sorts.
Paragraph
41. What is important to note is that a decision which is perverse, as understood in paras 31 and 32 of Associated Builders, while no longer being a ground for challenge under public policy, would certainly amount to patent illegality appearing on the face of the award. Thus, a finding based on no evidence at all, or an award which ignores the vital evidence in arriving at its decision, would be perverse and liable to be set aside on the ground of patent illegality. Additionally, a finding based on documents taken behind the back of the parties by the arbitrator would also justify as a decision based on no evidence, inasmuch as such decision is not based on the evidence led by the parties, and therefore would also have to be characterized as perverse. In this award also, the learned arbitrator has taken his own personal knowledge as an engineer. He has applied a formula for quantification of damages, which he says that this is a very popular or common formula in other government contracts, admittedly not in this contract. So he has taken that, he has used his knowledge for that, and he has not given that to the parties. So that is why it's in that sense, it is behind the back of the party, it amounts to no evidence. So this paragraph 41 of SsangYong, well, though it is to do with the new act, really SsangYong is important because after associated, the act was amended, and patent illegality became a ground for challenging a domestic award. Now, the one last decision that I want to cite in this aspect is Rajasthan 2009, 19. This one, State of Rajasthan, 2009, 12. Yeah. This HPCL versus Bono. HPCL. Well, the next decision I want to rely on, 2009, 12 SCC, page 1. State of Rajasthan versus Ferro Concrete Construction. And this was a case under the 1940 Act. That's why I want to show this, where reasons, lack of evidence, etc. were held to be good grounds. So this because if my learned friend again contends that in 1940 there is no reasons required, I've shown that if reasons are given, it can be gone into, and this is a particular case similar to that. Now here, I'll just see which part. One second. Page number, paragraph numbers will look at all the time. This is not my copy. Very well. If my lord comes to page paragraph 1, page 6. See which we cited. It's in our note. Our note here. Heard counsel, the appellants invited a tender for manufacturing and testing of a water pipeline for the length of 37 kilometers in the Ajmer district. Tenders were given. And I just want to show that it's from the 1940 Act, and then I'll come to the relevant part, my lord. Yes. Paragraph 17 on, sorry. Page 10, paragraph 17. Find the notes. Now we have referred to it in our notes. On the contentions urged, the question that arises for consideration is whether there is any legal misconduct or error apparent on the face of the award in regard to the award of the arbitrator in respect of such and such claims. Then paragraph 18. Section 30 of the Act, inter alia, provides that an award can be set aside on the ground that an arbitrator had misconducted himself or the proceeding, or the ground that the award had been improperly procured or is otherwise invalid. An error apparent on the face of the award is a ground for setting aside the award under 30, or for remitting the award to the arbitrator under section 16. Then in Yeah, that's what I'm saying. Yeah, that's what I want. Yes. Then paragraph 19, in Chamswe Bhara, the Privy Council explained the term an error of law on the face of the record. An error in law on the face of the award means that you can find in the award or a document actually incorporated thereto, as for instance, a note appended by the arbitrator stating reasons for his judgment, some legal proposition which is the basis of the award and which you can then say is erroneous. So if you can find it in the award that this decision of yours was erroneous, then it can be challenged. 20. It is well settled that under the 1940 Act, an award was not open to challenge on the ground that the arbitrator had reached a wrong conclusion or failed to appreciate facts, as under law. The arbitrator was made the final arbiter of the dispute between the parties. While considering the challenge to an award, the court will not sit in appeal over the award or reappreciate the evidence for the purpose of finding out whether the facts and circumstances whether on the facts and circumstances the award in question could have been made. When there is no allegation of moral misconduct against the arbitrator with the reference to the award and the arbitration has not been superseded, there are only two grounds of attack. First, there was legal misconduct on part of the arbitrator, and second, there was an error apparent on the face of the award. This court explained the principles relating to interference with the awards under 1940 in Puri construction. That's the state of Rajasthan versus Puri construction. An award rendered by an arbitrator is open to challenge within the parameters of several provisions of the Act. Since the arbitrator is the judge by choice of the parties, more often than not, a person with little or no legal background, the adjudication of disputes by an arbitration by way of an award can be challenged only within the limited scope of the provisions, etc. Well, here everything is restated. I'm not citing that. Now, my lord will come to paragraph 40. All the possible challenges are mentioned in this paragraph, which I'm not placing, but paragraph 40, yes, paragraph 40. The arbitrator also overlooked the fact that the additional provision regarding mobilization advance was introduced in the agreement itself. Therefore, mobilization was governed by the terms of the CTR, etc. If so read, it is clear that there was no breach on the part of the employer and contractor was itself responsible for delay. If so, the question of compensating the contractor does not arise. Then, my lord, 49. So if the contractor was also found to be a part causing delay, then my lord, the question of compensating him would not arise. Then 49. Yes. Further, the reasoning of the arbitrator is very strange and is a classic case of the error apparent on the face of the award and a legal misconduct. The arbitrator rejected claim 37A for payment of rupees 12,000, etc. as compensation for loss of production from such and such, on the ground that the plant had been mortgaged in favor of the employer and therefore there was no justification for the contractor to claim that it should be permitted to remove and take away the plant when the mortgage subsisted. Having rejected the claim, the arbitrator evolved a strange reasoning that though there was a subsisting valid mortgage in respect of mobilization advance with interest in favor of the employer, because he had made an award in favor of the employer for rupees such and such, the mortgage came to an end and the employer would be liable to return the documents, and if it failed to return the documents, the contractor would be entitled to damages of such and such. The arbitrator noticed the fact that the plant and machinery was mortgaged by deposit of title deeds in favor of the employer and the contract was the original documents remained and then it goes into the merits. But what I wanted to say, paragraph was 54. Yes. And finally, paragraph 54. I just wanted to show that because the courts have gone into the reasoning of the arbitrator. Now paragraphs. Yes, 54. This is also on the ground of no evidence. If I may start at 53, I'm sorry, the top of the page 21. There is no evidence that the contractor had other contracts which it was required to manufacture the number of pipes, or it could not manufacture the required pipes for want of plant and machinery. Nor is there any evidence of the value of the plant and machinery mortgaged to the employer, and what would be the cost of an alternative plant in which capacity to manufacture 15 pipes a day. If the plant was, say, value of 25 lakhs, or if the contractor could install another similar plant at the cost of 25 lakhs, then the loss at best would be interest on 25 lakhs and nothing more. In fact, even though there is no evidence, while making claim 36 and 37, the contractor has given the value of plant and machinery as 36 lakhs odd. Even assuming the figure to be true, at best the blocked up investment is only 36 lakhs odd, and the loss would be around 1% thereon per month by way of interest. What is more strange is nowhere in the award the arbitrator considers the validity of the claim of rupees 12,000 per day, nor accepts the said claim as valid or correct. In a reasoned award, if the claim of the contractor is equated to proof of the claim, then it is obviously a legal misconduct and an error on the face of the award. Then, 55. While the quantum of evidence required to accept a claim may be a matter within the exclusive jurisdiction of the arbitrator, if there is no evidence at all, and if the arbitrator makes the award of an amount claimed in the interest on the claim statement merely on the basis of the claim statement without anything more, it is to be held that the award on that account would be invalid. Suffice to say, the entire award under this head is wholly illegal and beyond the jurisdiction of the arbitrator and wholly unsustainable. And those are the decisions on 1940. So it cannot be gone into there also. Now what remains, my lord, is to show, my lord, the impugned order. And it was held that, no, that there were sufficient reasons. Every paragraph had reasons. And the it's really a bit contradictory because it says that, yes, and volume 4, my lord, page 461.
We have the memo.
The impugned order, yes. For a case for Yes. So first, in paragraph 2, my submissions are recorded. Now, senior counsel appearing for the petitioner contends that the award is vitiated, being devoid of reasons. Moreover, the award is perverse, being not based on any evidence. The case with the one that 96 Act, the 1940 Act, whichever is narrow. Thus, the learned arbitrator misconducted himself or the proceedings within the contemplation of Section 30A of the 1940 Act, which is a valid ground for setting aside. Then, my lord, I had cited this last case which I cited before, my lord, State of Rajasthan versus Ferro, for the proposition that an arbitrator can be said to have committed a legal misconduct by ignoring the terms of the contract. In the said case, the arbitrator overlooked the fact that an additional provision regarding mobilization advance was introduced in the agreement itself. And I just placed the decision, I had placed the same paragraphs 53, 54 for the purpose that no evidence, the perversity is a ground. It is not only this, of course, the learned judge has written this, that by ignoring the terms of the contract, but there were several other grounds and propositions in this State of Rajasthan case which are applicable and were not considered. That in the 1940 Act also, the reasons can be gone into. In the 1940 Act also, no evidence amounts to perversity. These two propositions were not clearly, he has just summed up a part of the judgment. Then, Council also relies on division bench of the state of West Bengal and Bharat Banijjo, where it is observed that reasons are the links between facts and conclusions, and they reveal the application of mind, and the reasons are the lifeblood, etc. But also I had relied on this decision to say that mere lip service, by saying that I have considered the letters, I have considered the evidence, and I come to the conclusion that the state is responsible. That is the lip service. That point was also not really considered. Then Diana Technologies was also cited. The characteristics of reasons were found in the judgment to be proper, intelligible, and adequate. That I have placed. That's fine. Then Bharat Coking Coal and LK Ahuja. This is the 2004 decision. This is on the damages. Enunciated that loss of opportunities must be proved by evidence which is well settled and accepted. So the learned judge accepts that proposition. There it was said, there's that paragraph 24, which I had placed, and it's a part of Justice Dipankar Datta's that Unibro judgment, which I had cited. But there in Sarvesh Chopra, it clearly says that you have to prove that you had other contracts pending or opportunities there were to put in this money if you had got, and you would have earned some profit from that. There was no such proof in this case. In fact, there was no oral evidence in this particular case. So, Manoj, the Sarvesh Chopra, that principle vitiates all the claims because all the claims are damages. And without proof of the resulting loss, it cannot be allowed merely for the asking. Or then the next, relying on Unibro, counsel appearing for petitioners argues that it becomes imperative for a claimant to substantiate the presence of a viable opportunity through evidence. The evidence should convincingly demonstrate that had the contract been executed promptly, the contractor would have secured supplementary profits utilizing its resources elsewhere. Now, again, this is just a part of this decision. There are two full paragraphs, the last two paragraphs, I think paragraph 15 of that decision, which clearly says what are the not 15 cites this, I'm sorry, paragraphs 16 and 17 clearly say what is the evidence that is required. So it says what would be the nature of quality of evidence. In our opinion, it would be contingent on the facts of the case. However, it may generally include independent contemporaneous evidence, such as other potential projects that the contractor had in the pipeline and would have undertaken had, if not for the delays, the total number of tendering opportunities that they had received, financial statements, etc., etc. One exhaustive list is given. Or rather, it says it's not an exhaustive list, a huge list is given. And there are other points also. So in our case, none of the how he suffered loss is really gone into, or it has not been proved also. Then Malak Sangyong, which I cited, which says that perversity is still a good ground, and this will also apply to 1940 Act as appears from the Rajasthan case. Then this is one issue that the learned judge got in with me, Malak, that paragraph 9 of the impugned judgment. It's not so important for the setting aside purposes, but maybe something that requires clarification. It is contended that the grounds of challenge of an award under the 1940 Act are much broader than those provided under Section 34. Giving reasons is submitted as a basic requirement of natural justice. Now, this later the learned judge goes on to say that the 1940 Act has only two grounds, misconduct and error on face of the record. Therefore, it is much narrower than the 1996 Act. But the 1996 Act was incorporated with the statement that there's too much of his judgment. No, I want to show the other decision where it says 96 is broader. It's narrow. In fact, so 96 is narrow.
96 Act এত restricted ছিল কিছুই ইন্টারফিয়ার করা যাচ্ছে না এই জন্য পাবলিক পলিসির মিনিংটাকে আস্তে আস্তে বাড়ালো Yes, Mr. Ghosh, you may have to stop because 15 minutes we have kept for a particular matter.
I'll just finish this, placing this and my comments on the award. So I should
Yes.
be done in 15.
15 minutes. When do you want to do it? Tomorrow?
Yes.
91 years.
91.
কালকে কখন হবে এটা?
আগের বছর 86 ছিল, এই বছর 91 আছে।
First half is promotion.
No, first half is appellate side. তুমি বলো না। কালকেই তো লাস্ট ডে।
এটা কমার্শিয়াল নয়?
তাই টিউসডে করি।
কমার্শিয়াল অরিজিনাল সাইড। সোমবার রাখো। Keep it on Monday then.
Tuesday. Because Monday is a Monday first. Tuesday.
হ্যাঁ শোনো কালকে ফার্স্ট অ্যাপেলেট সাইড হলে
তারপরে কমার্শিয়াল
টিউসডে তাহলে ইয়ে হবে অরিজিনাল সাইড হবে
91 তো করে দিই।
ঠিক আছে আবার তুমি বলছো কালকে অ্যাপেলেট সাইড হবে কিনা করে দাও বললাম না অল্টারনেট ডেজ হ্যাঁ ব্যাস জাস্ট দ্যাট না পাল্টে দাও এভরি অল্টারনেট ডে বলে দাও মানডে ওয়েডনেসডে টিউসডে বলার দরকার নেই তোমার হ্যাঁ এভরি অল্টারনেট ডে বলবে Mr. Ghosh from a learned senior counsel representing the appellant resumes his argument but does not conclude. Paragraph. List this matter once again on Kobe.
On a day when the lordship takes up.
Original side in the first half. Alternate days, Ms. Banerjee now. Today, first half was?
Today.
Not all day. If all day original side continues, yes, all day. So today original side was taken up first. Tomorrow appellate side will be taken up first. Next day, whichever day it is, original side, even if it is Tuesday.
Tuesday.
13. Now we are changing the rule. We are changing it. 13, May 13. As the first item under the heading appeal from order. Finish it off, round.
Yes, and on
Wind
the
it up.
next order will not is to be placed. Then if my learned senior friend is not there, will not she can start.
Yes, she can.
If you wish to rely on any decision, kindly supply the citations so that they can come prepared.
There, I think it's already in the imbued order. So, unless the new.
No, she might spring some surprise. You don't know. Latest, yesterday's pronouncement of the Supreme Court.
There is one or two, I'll share.
Share it.
Please matter 315, item 30.
How can task not to hear arguments? Sorry, I yawned, no disrespect, but I yawned at least 15 times, Lord.
এই একবার লাইভ স্ট্রিমিংটা বন্ধ করো লাইভ স্ট্রিমিংটা You want to file any reply to that? Reply thereto, comma, if any be filed by May 19. Paragraph, list the matter on May 20.
On 14, I will not be appear here because I am going to Chennai for a meeting.
On 14, the matter.
When are you going?
I will go on 13.
And we'll come back when?
Back on 16 because one evidence is in Delhi.
We are keeping it on 20th of May. Oh, affidavit. You give instruction to your counsel, she will draw it.
Lordship, the
Oh, she has to.
of the official liquidator may be dispensed with.
Okay. No, that's it.
Yes, 7.
Who will affirm the affidavit?
Exactly. Exactly.
Assistant. Yes.
Lordship,
তাহলে দেখো, we would like the office of the official liquidator to file an affidavit. Well, না বলে এখানটা বলেছি না, we would like the official liquidator. We would like the office of the official liquidator to file an affidavit.
Lordship, on 20th, his personal appearance may be dispensed with.
Personal appearance dispensed, but we would request him to be present. We are not directing. The personal appearance of the official liquidator is dispensed with. Stop. We are not recording anything, but try to be present, Mr.
Grateful.
Deeply obliged, my lord, deeply obliged.
Hey.
Hey,